मैं just I am planning for listing ये मतलब तो motion matter on Friday में
What is your subject matter?
motion matter
What is your subject?
मतलब तो the matter regarding मतलब एक election मतलब और पंचायत मतलब वार्ड member मतलब the
Okay. May I please, your lordship, my lord, the item number 11 may be taken up at 2, my lord.
Item 4, lordship. The urgent matter, I have taken consent of my.
Four. Item 4.
Item 4. Item 4.
Yes.
Adjournment for that allowed, and it may be fixed. It may be fixed. My sin
Yeah.
is not well.
On the prayer of Mr. James Suleiman, and counsel for a petition. What is your subject matter?
It's regarding some compensation they are seeking. There was dumping of riverbed soils on their land. That is the claim, and they say that because of that, their crops have been demolished, or it has been, land has been rendered unfit for further cultivation. So that's why they are seeking a direction in the nature of a compensation from the court. So today he says that his senior is unwell, so that I cannot object to that. If your lordship kindly fixes a date,
Okay.
then it will be.
Has sought for an adjournment on the ground that Mr. H.R. Chaudhary, Land's senior counsel, who is leading him in this case, is indisposed. Post of Mr. S. Doctor, Land's senior counsel, appearing for respondent number 2 and 3, has submitted that he has no objection to the prayer so made in view of the ground cited. Post of as sought for and agreed to by the Land Council for the parties. Released the case on December 2nd with detail.
9/12. May it please, Lordship. I am playing for listing a motion matter. Lordship permits tomorrow, my lord. Now, bank account has been freezed in spite of the interim order passed by the honorable court, my lord.
Friday.
Much obliged.
That you have back to mention for listing of a pending writ petition. Here the GMC has sealed the shop premises of the petitioner without issuing any prior note.
Motion.
No admission. No.
Okay, next week detail.
Please, your lordship, I pray for listing a matter of admission.
Admission, subject.
Matter is non-payment of compensation.
Give it
Amount
to
by
the court.
Kala.
Give it to the court master.
May I please, your lordship? Lordship, I beg to mention item 5. Lordship, we have received instruction. So lordship, we need a quick time for verify.
You are appearing for whom?
Lordship,
You are appearing for whom?
petitioner.
Huh?
Petitioner.
Petitioner. You need time to file affidavit in reply or what?
No, lordship, we need time to verify the instruction, lordship.
Okay, on the prayer of Miss
S. Nazneen.
S. Nazin Land Council appearing for the petitioner. The case states adjourned for 2 weeks. Mr. N. Goswami, Land Junior Government Advocate for the state respondents, being in attendance, I have submitted that he has no objection to the prayer. Is the case accordingly after 2 weeks on a date to be fixed by the office.
May it please, your lordship. I beg to mention item number 3, your lordship. We have received their affidavit in opposition yesterday only. Lordship, we need time to file our reply.
Affidavit in opposition by whom?
By respondent number, by respondent number 7, 8, 11, 20 and 30.
7, 8,
11, 20 and 30.
20 and 30, 20 to 30.
20 and 30.
20 and 30. Okay. Miss
S. Sharma.
S. Sharma, Land Council appearing for the petitioner has prayed for, sought for and is granted. How much time?
Lordship, 2 weeks.
2 weeks time to file
Let them come.
an affidavit in reply to the affidavit in opposition file on behalf of the respondent number 7, 8, 11, 20 and 30. Post of. Anybody present, Mr.
Lordship, I am appearing for respondent number 6. Lordship, I come after vacation.
Okay. Mr. B. Chaudhary, Land Council for the respondent number 6 is present and has submitted that the matter be listed in the month of January 2026.
Lordship, can it be on December only?
No, December not feasible. Okay, release the case accordingly on a date in the 26th. On a date in the week commencing from 19 January.
Obliged.
May it please, your lordship. Lordship, I beg to mention item number 10, your lordship. Yesterday, I have submitted adjournment slip, your lordship. Lordship, learned arguing counsel, Mr. A.W. Aman is out of station, your lordship. Matter may be adjourned for the day, your lord.
You are Mr.
Mohammed A. Rahman, your lordship.
A. Rahman. Mr. A. Rahman, learned counsel for the petitioner, has made a prayer for adjournment. By submitting that a mention memo to that effect has already been submitted yesterday with the consent of the learned counsel for the respondents. This is the case. The price allowed, this is the case after 6 weeks. But this is 2018, okay, after 2 weeks.
Highly obliged.
May it please your lordship, I beg to mention for listing of a read petition lordship.
What is the subject matter?
It's Land acquisition.
For admission,
Yeah,
give it to the court master.
mass of lights.
May I please, your lordship? Lordship, item number 2, your lordship.
Hmm,
In this matter, pleadings are completed. Can it be a matter may come up in the hearing column?
okay.
Lordship,
Yes.
I am agreeing for the, we have already filed affidavit, the issue involved in this case. Regarding payment of interest on direct payment. Yesterday, Lordship had the matter.
Ah,
Lordship will fix tomorrow. Lordship asked me whether there is a notification to, Lordship notification is there.
okay, let it be after 1 week, this one.
Lordship.
You have already filed your,
Yes, I have already filed.
Yes,
my-
okay, on the prayer of Mr. P.K. Bora, learned counsel for the this is 2023. Okay. Mr. P.K. Bora, learned counsel for the petitioner, and Mr. S.C. Kyle, learned standing counsel GST are present. The learned counsel for the parties have submitted that exchange of pleading is complete. The petition is admitted for hearing, release the case for hearing in due course.
Interim order dated in
Interim order. Okay, interim order. Possibly shall continue to.
Pleasure.
May I please, your lordship? Lordship, I
Yes,
beg to
lordship.
mention for listing of a read petition, lordship, in motion column, lordship. On
What is
fi-
the subject matter?
Lordship, it is a GST matter, Lordship, whereby the GST authorities have issued one demand notice stating that the petitioner has wrongly availed the input tax credit,
Monday.
Lordship.
Supplementary list for motion, item 12.
May it please your lordship. My lord, the petitioners before your lordship, my lord, they are members of the Central Selection Board of the Bodoland Territorial Council. The petitioner number 1 is the chairman, and my lord, the other 3 petitioners are the members. My lord, they have approached your lordship, my lord, for giving an
Dissolution.
order. Your lordship may kindly first see the order of their constitution that your lordship will get at page 13. Page 13, may I read it, my lord?
Yes.
In pursuance of the decision of the Executive Council meeting of BTC held on 16 August 2023, white para number so-and-so, Bodoland Territorial Council is pleased to constitute an interim central selection board until further order. Now, my lord, the petition number 1 is Deepak my lord Basumatari at serial number 1. Petition number 2 is at serial number 2. Petition number 3 at serial number 4. And petition number 4 is at serial number 9. Now, my lord, although this is for my lord until further order, but there is a clause your lordship may see in the terms and conditions.
Hmm.
The members of the interim board will hold office for a period of 1 year, which may be extended if situation warrants. So this was, my lord, in effect for a period of 1 year. Then, my lord, one relevant clause your lordship will kindly peruse next page at clause 3. There is a procedure for removal. The chairman of the board may be removed from his office by the decision of the Executive Council of BTC. So also the other members of the board. Now, my lord, these boards, my lord, they select the grade 3 and grade 4 and other, my lord, non-APSC posts. So that is also reflected in, my lord, subclause 1 of clause 3. Now, what happened, my lord? There has been extension from time to time. And finally, by page 17, my lord, 31st of July 2025, it was extended for a period of 6 months And my lord, that lasts till 31st of January 2026. Page 17 is the, my lord, last extension order.
Hmm.
That is also, my lord, by the decision of the, my lord, council, my lord. Now, and two orders have been issued by which the petitioners are aggrieved. First is at page 19.
Yes.
This is issued by the Principal Secretary of the BTC. As directed by the Honorable Chief BTC, all non-statutory, non-elected ad hoc organizations, boards, committees are hereby ceased to exist from immediate effect. The concerned Secretary of the Department shall issue separate notification with respect to the bodies as mentioned above immediately. Then following this, my lord, the order at page 20 has been issued. This has been issued by the Secretary BTC again, my lord. In pursuance of the OM number so-and-so dated 9/10/2025, the Interim Central Selection Board BTC constituted by notification dated 12/1/2024 is hereby ceased to exist with immediate effect. Now, my lord, the petitioners are aggrieved by these two orders for two reasons, my lord. Basically, primarily, my lord, there is a procedure laid down in the, my lord, order of appointment itself, my lord, the constitution of the committee board itself, my lord, that this has to be done. That, my lord, clause 3 that I just read. The chairman of the board may be removed, page 14, clause 3, may be removed from his office by the decision of the executive council of the BTC. So, my lord, there has to be a decision of the executive council, and, my lord, this procedure has been laid down in the order of constitution itself, my lord. But your lordship will see the two impugn orders. This is only the desire of the, my lord, the chief of the, my lord, BTC. So this is one, my lord. Secondly, even if, my lord, they want to remove, my lord, the petitioners are entitled to, my lord, personal hearing. A hearing, an opportunity of hearing must be given. Now, one question may arise, my lord, this is a 10-year post. My lord, this is a
Interim by nature.
My lord,
Interim by nature,
interim by nature,
not
but
an elected body,
not an elected body, my lord.
nominated.
And whether this is a pleasure tenure, this question may also arise, my lord, because in similar case, I have already moved another case and the stay has been granted. My learned friend was agreeing to that, my lord. In fact, she helped me in getting that. Now, two aspects, my lord. One, the procedure that has been laid down has not been followed. And secondly, my lord, no opportunity has been given to the party. And there is a decision, division bench decision also, if your lordship permits, my lord, I'd like to place that on the same issues. This was regarding, my lord, the Subdivisional Welfare Board for Scheduled Tribe. Your lordship may, my lord, come to paragraph 17 to 20, my lord, the questions that arose before the, my lord, division bench for consideration, those has been discussed, including the issue of, my lord, the pleasure tenure. May I read it, my lord? Paragraph 17. The next question which requires our consideration is whether the state really formed an opinion in terms of the guidelines published in the notification dated 22/2014 before dissolving the boards. We have already reproduced one of the many notifications, paragraph 9 of the order dissolving Subdivisional Welfare Board for Scheduled Tribe constituted by the department. According to the notification, all the boards were dissolved in the interest of public and smooth functioning of the central and state sector schemes for the development of scheduled tribes. The notification on the face of it does not reflect any formation of opinion by the state that circumstances so existed whereby orderly conduct of business of the existing boards was not possible. Also, there is nothing on record to establish that individual assessment of the orderly conduct of business of each board was made before dissolving it. On the contrary, original records produced by the state pursuant to our direction reveals that despite two detailed well-reasoned opinion dated so-and-so by the Joint Legal Remembrances Judicial Department and dated 29/9/2026 of the Joint Secretary Judicial Department against proposal to dissolve the boards before the first forming an opinion. and stipulated in the guidelines of the notification dated 22/2014, the boards were dissolved most arbitrarily on the instruction of Minister of the Welfare, Plaintiffs and Backward Classes Department. Here, my lord, this is the, in our case, my lord, the desire of the chief. Now, paragraph 18. As seen above, unlike earlier notifications, for the first time in notification dated 22/2014, the guidelines were laid regarding constitution of the boards, appointment of members through selection by a selection committee, term of the office of the board, condition for removal of the boards and condition for removal of the members of the boards. Apparently, the salutary imperative condition of first forming an opinion that orderly conduct of business of the board was not possible was deliberately introduced to check arbitrary resolution of boards by the state government, which was perhaps being done in the past and were held to be valid by the courts on the plea of doctrine of pleasure. Importantly, for dissolving the boards, requirement is formation of opinion by the state that orderly conduct of business of such board was possible and not merely smooth functioning of the central and state sector schemes for the development of the scheduled tribes. For these reasons, we have no option but to hold that the entire action of the state in dissolving the hundreds of boards by one stroke of pen is not only arbitrary but also illegal, which cannot be allowed to sustain. There is yet another reason to declare the action of the government dissolving boards as illegal, and that is violation of principles of natural justice. Admittedly, no one member of the board dissolved was given an opportunity of hearing to convince the state that there was already smooth functioning of the central and state sector schemes for the development of scheduled tribes, and such smooth functioning would continue. This being the situation, the government has illegally exercised the power to dissolve the board, which it has said the impure. Now, my lord, here the procedure has been laid down in the order of constitution itself. My lord, there has to be a decision of the council. The council has not taken any decision.
Yes.
Order giving.
First, I take your lordship to the order how the board were constituted at page 13, my lord. In pursuance to decisions of the Executive Council meeting of BTC held on 16 August 2023, white para number so and so, BTC is pleased to constitute an interim council selection board until further orders. Lordship, this was for a period of 1 year, your lordship, clause 1. The members of the interim board will hold office for a period of 1 year, which may be extended if situation warrants. Lordship, this order was issued on 12/1/2024, so it should be valid for 1 year, so throughout the year, your lordship. Then, your lordship, next page, my lord, by order dated 4/3/2025, it was extended for another 6 months, my lord. At page 15, your lordship has got it. It was extended for another 6 months. Then from March to, it should be from till lordship September, 6 months. Then what they have done, your lordship, on 31/7/2025 at page 17, my lord, in continuance of earlier notification number BTC dated 4/3/2025, and in pursuance of approval of the Honorable CM BTC, the Borderland Territorial Council is pleased to extend the term of the interim selection board BTC Kokrajhar for a period of 6 months. Lordship will see the effect 4/9/2025. Your lordship will kindly note this date. 4/9/2025. Lordship, what happened? Why this date? This has been done according to us in a most surreptitious manner because of the reason that on 26/8/2025, election code of conduct has come to effect, your lordship. I have notification to your photo. So they have given this, they've issued a notification on a prior date on 31/7/2025, and effect was given with effect from 4/9/2025 when the Election Commission notification regarding code of conduct was in operation, my lord. So in that event of the matter, this order of extension is lordship bad in law. Another point is that lordship, these appointments are lordship pleasure appointments. The pleasure of earlier BTC chairman chief, my lord, Pramod Boro, your lordship. Now, since it's a pleasure appointment, it is not an appointment which was made under Article 309 of the Constitution of India. It was only on the basis of the political consideration, my lord. So, your lordship, it should not be backed by any lordship notice, my lord. Opportunity of being heard cannot be given to them, your lordship. And no service rule is followed in case of pleasure appointments, your lordship. So, your lordship, since it was not an appointment under Article 309 of the Constitution of India, so my respectful submission is that the procedural mandate at NVC is, my
So
lord.
second notification was when?
Second notification, my lordship
Fourth
will
March.
kindly see, on 31/7/2025. No,
May.
last one is 31/7. Second one is, my lord, 4th of March, 2025.
Right.
4th of March, for till 6 months, it would be from till 4/10.
So it was expired
4/9.
on 4th of September.
Yes. Effect is given, but notification was issued to a prior date.
31st of July.
Yes,
So election revision came in 26th August.
yes. Effect
it
is
was
given,
prior
Lordship
to
will
that.
kindly see. Yes, it is.
It was
But
prior to that.
Lordship will kindly see with effect from, that is on 4/9,
That is
2025.
natural if you come to page 15,
Yes,
4th March.
yes,
If you count 6 months,
yes.
it will be 4th of
4/10
September.
of 4th of September, yes,
Yes.
yes.
So that will be, extension will be only from 4th of September.
Yes,
There is no hard and binding rule that it cannot be done before 1 month.
but Lordship admittedly, these are pleasure posts.
These are the normally
Terminus.
privacy.
Yes, my lord. Lordship, may I?
Privacy, it is 31st July.
Yes,
It is no harm
my lord.
in extending the period prior to 1 month.
And by that time, your lordship, the new government has, a new BTC council has
New
taken
government may
over,
come
my lord.
and there is a method.
Lordship,
There is a method in your everything, everywhere it is reiterated.
my lord,
Come to page 13,
pace, my lord,
first notification.
yes,
Page 14, chairman of the
Yes.
board
yes,
may be removed
yes,
from his office
yes,
by the decision of the executive council of BTC.
yes, yes,
So also the other members.
yes,
Then page 16, clause 3. Then page 17, clause 3.
yes, my lord.
The procedure is laid down. That
Yeah.
was also an elected body. They have reiterated.
But that is a,
But here, see the language. As desired.
yes, yes,
He
So-
may be the head of the executive council,
yes,
but he is not authorized to take a collective decision on behalf of the executive council.
that is subject to correction whether any decision has been taken by the executive council.
It is there reflected.
No, no,
As desired.
no, no, and there
That
has
is a
to be-
different issue.
Yes, whether any decision has been taken, first as desired, next is any
When they
decision.
took oath,
My lord,
when they took oath of office.
lordship in the month of, maybe in October, your lordship.
It cannot be as per whims of the chief. It has to be on the face of it, principal secretary said, office memorandum as desired by the honorable chief, BTC. No mention of any executive council
No,
decision.
no, it says so. On the lordship
Page 19,
is 19.
why you have come so late?
My lord, this was communicated a little late, my lord, although this was issued on, my lord, the last order is 13th October 2000.
It is more than
But then, my
1
lord,
month.
they are functioning, my lord, we have made a
I don't
statement.
think so that they are functioning.
So
my lord.
paragraph 7.
Let me take instruction from my
page
client,
7,
your lordship.
paragraph 8, my lord.
I'll be relying on.
We are
does
holding, my
not-
lord, selections for the, my lord, page 7, my lord, paragraph 8. We have not handed over charge to anyone. No new committee has been.
With immediate effect.
Paragraph 8 you have stated, my lord,
9th October, we are in November, my lord, mid-November. Today is 18th, your lordship.
but we are functioning. And selection process are going on. We have not constituted a new body.
As my learned friend has submitted, 2 weeks back, they have moved a petition. That is, all cases depend on its own facts, your lordship. Just because they have got an order of status quo, my lord. So
Ordered, how-
they have probably have come up before this honorable court with the same.
In another case, my lord. we
This
have
term is?
Already a status quo order was granted, my.
Yes.
In another case, we moved.
That was I was
it
submitting
uh,
because
regarding
they were
development
in
of-
operation and that order was issued by the government of Assam.
Which order?
No, that order they have challenged, my lord, initial order of their appointment of the term, that was given by government of Assam, my lord. Dispur. On the
Here
ground.
also, my lord, the as desired by the same order, my lord. Same orders have been challenged in that petition. The two orders we are impugning here, those are.
But it is a statutory body.
That is a statutory.
Here, principal secretary is the appointing authority.
Oh, where?
Here in the instant case, my lord.
In the instant case.
Yes.
But it is executive council decision.
Principal secretary BTC is the issuing
He
authority.
issues the notification.
Yeah, he issued a notification, but in that case, which was referred by my learned senior
Executive
friend.
council is equivalent to cabinet.
Yes, but here,
He carries out the direction
yes,
of the executive.
my lord,
council.
at the face of it, this order which have, my learned friend has got the status quo, is issued from the Dispur, my lord, authority from Dispur.
No, the same.
But
orders-
method is there, right, they are desired they are from the principal secretary. We have to go by the principal secretary's own language as desired. When the appointment is by executive council, the normal procedure is that removal is also by the, should be by the executive council. If the appointment is by cabinet
My
decision,
lord,
then removal is also to be by the cabinet decision. It is not there that it has been delegated to.
but
without
your
any-
lordship, at the face of it, this person's lordship, they are not appointed under Article 309 of the Constitution.
Right. But the procedure
My lord,
you have already laid down
my lord,
that they have to be removed by a decision of the executive council. Is it not?
my lord.
So you have reiterated in all the three notifications that members and chairmen are to be removed by a decision of the executive council. So as desired by HCM is completely contrary to that.
My lord, the-
Whether he is a member of the executive council,
Who?
this chief, my lord.
Yes,
Yes.
but he cannot take the collective decision.
Yes, so lordship, may I take instruction from the authorities concerned? Lordship, whether it was like done as per the mandate which had been envisaged in the notification, because
We go with
admittedly
the
they have
principal
come late.
Principal secretary of BTC, who is an Indian Administrative Service officer. You would not
such an order.
commit such.
My lord, the oath was taken on 5th of October.
And this, after that, executive council is formed when?
No, new council has gone on the same date, no? No,
No.
it must be later, my lord.
Must be later. Maybe there was no existence of executive council when this order is passed.
Maybe, my lord. Maybe.
Let me take instruction, my lord. Let me take
Check
instruction.
right now.
Maybe a bit
If there
difficult,
is no executive council, then
No,
this
no,
order is
can
bad, totally bad.
my lord. Tomorrow then, my lord, tomorrow. Tomorrow it may be taken up.
If no executive council, come up.
My lord.
Okay. Mr. Chaudhary, you will not be there.
Tomorrow, my lord, my elder brother's first at the service.
Oh.
The Kukubar
Okay,
to-
tomorrow I'll take up, Mr. Bordwas will be there. Only this issue. If there is no existence No decision
Yes.
of executive council, then
My lord,
this
whether
order
the
will be,
executive
will
council
be
was
kept in
there,
abeyance.
Whether the executive council was in existence or not.
No, no, that is not the issue.
My lord,
Executive council decision. If there is no decision,
that is reflected in the order itself. My lord.
yes. You take decision
I'll
today.
take instruction.
Today,
Lordship,
today.
yes, when you will be there, because
Today.
I'll be stuck in division bench, your Lordship understand.
We'll take
Opposite
two.
court. পৰহি থাকিবতো। কালি পৰহি থাকিব, আপুনি নালাগে?
We'll take up it too, no issue. Whether there is executive council.
When it was formed. Whether
No.
yes,
When it was formed, that is one secondary
My lord.
issue. But whether
Doesn't exist.
there was executive council decision to dissolve the body. If there is existence, then the situation will be different.
ma'am.
And these are body, high-powered body otherwise.
Yes.
Selection committee just next to my lord APS.
Lordship, I'll be relying on certain judgment, not now, to
No, not required. Simple thing,
Honorable, our High Court and Honorable Supreme Court also.
we know it is nominated body, it is interim body, but as per the division bench judgment, when the procedure laid down to remove or dissolve the body, then that procedure must be followed. To my understanding, that is the only question.
Lordship, I'll take
Otherwise, they have no right
instruction. My lord,
to continue.
my lord,
But question is whether the procedure has been followed.
followed
or
or not,
Like say section 16,
my lord,
power to appoint
my lord.
contains the power to remove.
Remove,
Now, power to appoint is Executive Council BTC as per the three
my
notifications.
lord.
So power to remove
Is
is also by the Executive Council,
My lord,
not
that is-
as the part of desire of somebody.
But at the same time, it is a Lordship, pleasure post, your Lordship,
No, but question is when it is a collective decision,
my lord.
it cannot be superseded by an individual decision. You have a cabinet.
My lord,
It might consist of 15 persons. All are elected member.
my lord.
Just because one has been declared to be the chief minister,
My lord,
that he cannot take his own decision. Administration do not run in that way. Take instruction at two.
Lordship.
Obliged.
If executive decision is there, council decision, then okay.
Daily
Lordship,
list,
kindly accommodate me if I, 5-10 minutes.
daily list for admission, item 1.
May I please, Your Lord? My lord, in this case, on 8/1/2019, son of the petitioner had expired due to electrocution, Your Lord. While he was cleaning a dumper which was parked at public road, Your Lord. Under the jurisdiction of Boithalangso Police Station, District Karbi Anglong. On last question, Your Lordship, the coordinate bench instructed some extra copy to the FPDCL. We have some.
May I please, my lord? Yes, ma'am, for the APDCL, my lord.
Hmm.
My lord, as per the electrical inspector report, my lord, there is a contributory negligence on the part of victim as well as the, my lord, APDCL, my lord. So I have sought for the instruction on the last occasion, they, since they have, my lord, served the copy. We have been implemented later on at the stage, my lord. So, my lord, my instructions are awaited, my lord. They have sought for some time, my lord. Lordship may take it up on Thursday, my lord.
You have not
When-
been impleted earlier.
No, my lord.
No, Lord.
At the filing the time of repetition, my lord, we are not there, my lord. Only on the last date, my lord, we have been served a copy of the repetition. So my instructions are that, my lord, the department are intending to file an appeal against the report of the electrical inspector report, my lord, as per the 162 subclause 2 of the Electricity Act, my lord.
That has been served long back perhaps. When is the inquiry report?
My lord, it's an affidavit filed by the government, my lord, chief electrical
Ah.
inspector.
At page 28, Your.
33/2024.
Yes, my lord. That also been served on the last occasion, my lord.
Inquiry report at page 8, Your Lordship, in addition, affidavit.
As your lordship dropping.
Nature of
The
exceeding factor.
report is at
This petition is structured claiming compensation under notification 15/11/2014.
Yes, no. But
Which one? Notification.
notification, your lordship, at page 23, as for the notification dated 15/11/2014, your lord. Public place here. Because the dumper was parked on public road, your lordship. Here number 3.
Monday, if it is the instance.
The entire petition is prepared and structured on the basis of notification dated 15/11/2024.
Yes.
Ex gratia to the next of kin of persons killed due to accident in public places.
Lordship.
There is no pleading
No pleading
or
regarding that.
claiming
And
compensation from the APDCL.
Yes.
in addition to that, lordship, I can show most probably he is not entitled to. I can show. From his own writ petition, lordship, on his own declaration.
What is that?
Page 3, sorry, page 5, paragraph 3. That the petitioner begs to state that on so and so at about his son, namely so and so, was cleaning and washing a dumper bearing registration number so and so, as he was the handyman cleaner, which was parked by his driver on so and so, so and so. And when he lift up the top of the vehicle to clean the same, to touch same, it touched the 11 kV electricity wire. So he is not the driver. He cannot operate. He has got no authority to operate the vehicle. So he is the handyman, lordship. While lifting the body of the, so it is operating the vehicle.
Which was parked by its driver. Now that backside was.
Yes, most probably that one. That's because it's a dumper. If a person climbs up the pole of a electricity post, lordship, and touches the wire in a public place, whether he is entitled to get that as gracia, so he is being a handyman, I think he is not entitled to. That's because he has operated the vehicle.
Own doing.
Lordship. Had it been a case that the driver has lifted it, he was inside, he died, then the matter would have been different most probably. I would not have argued this in this line. But here, lordship, it is apparently he has lifted.
So did you file any application under Workmen Compensation Act?
No, lordship. I have no idea about that.
No idea is no answer.
But they are
No
not,
idea is no answer.
but they are not applied before the electricity department for any company.
No
I am
compensation.
aware of that.
You cannot straight away come. This is one. And you are entitled under workman compensation.
Yes,
Act,
Lord.
Employees compensation Act, as
From
a
the
driver
employer.
or handyman. If you have a policy,
On last.
you are silent on that aspect. Writ petition is not structured to claim compensation from APDCL. 15/11/2014. It looks like it is your own doing. Accident, accident. Despite taking due care, caution, it happens, then it accident.
Neither he has got a valid license to operate that.
Operate a dumper, washing, you lifted the body, it is your own statement. So don't think it will come within 15/11/2014 also.
Lordship.
Hey, employees compensation Act concern. So you are unauthorizedly operating the dumper. We don't. If it is in the course of your employment, you are entitled to get compensation under Employees Compensation Act. Accident arising out of or whatever.
Lordship,
Death
give a date.
arising
I
out
have to
of
take
and in the
instruction
course of
about-
employment.
Yes, in the course of employment from the employer.
Employees Union Compensation Act. If there is insurer, you'll get the compensation from the
Insurance
insurer.
company,
Or if
otherwise
it
from
is
the employer.
not, then owner.
Lordship.
Yes, Lordship, I have a order passed by your Lordship. There is mention, your Lordship, the
If
other
personal
remedy
injury
may
is
be.
caused by accident arising out of, employer
By
shall be
him.
liable.
Content.
But this will not come within the purview of this. There has to be involvement of a third party.
Lord.
I think this later on has been this modified, this
Modified, yes.
recently.
31/10/2000.
Huh? Only in case
Exclude
of
the
third
matter-
party and something.
Yes, unidentified verification.
This does not envisage that you create, I think, one was making some ball, I said that it is
Yes.
not. Inside his home, he was preparing something
Lordship.
and there was a blast. He died. I said, it is his own doing in his own home, no third party. And it is not nature, that disaster.
Lordship.
Basically, it is disaster
Disaster.
management. Mr. Akon, I don't find anything. You are maybe entitled under Employees Compensation Act.
Absolutely.
But
The
here
PDCL also,
you are
as per your Lordship's order.
Let us see. No point keeping it pending. Though these are beneficial legislation,
Lordship.
APDC has
Last
a
paragraph, 19. Right. And
this is regarding framing of this
Uh,
thing.
But
But you did not structure your case.
that is the reason. On large occasion, honorable court also someone to advise me, you why not structure.
You have not structured. We cannot go beyond the relief.
Lordship,
We cannot go beyond the relief.
also old matter, so.
Whatever. It is the lawyer's case is prepared by the lawyer. Hard. Mr. S. I. Akan, Learning Council Board of Petitioner. A. Bhattacharya. What is your judgment? Mr. A. Bhattacharya, London Standing Council Revenue Department. For the response number 1, any finance? Mr. H. Sharma,
326.
Learned Additional Senior Government Advocate, Assam. For the response number 326, and Mr.
Yes.
B. Das, Learned Standing Council, APDCL. For the response number 7. Post of. The petitioner, as the father of one Sahanur Ali, has instituted the present writ petition under Article 226 of the Constitution of India, seeking disbursement of ex gratia grant in terms of a notification bearing number, page 23, dated 15/11/2024 or 14, which has specified for ex gratia amount to the next of kin NOK of the person killed due to accident in a public place or public carriers within bracket other than killed by extremist, terrorist, miscreants, and due to firing of security forces. Full stop. Para. According to the petitioner, his son, Sahanur Ali, was cleaning and washing a dumper bearing registration number AS-01/JC-9921, where he was the handyman cleaner. Full stop. Full stop. The dumper was parked by its driver on Paulagog, that's Pomakuchi Road at village Paulagog, Post Office Amguri, Police Station, Boitalangso District, West Karbi Anglong, Assam. Full stop. While cleaning and washing, Sahanur Ali lifted up the top of the vehicle to clean the same. And at that point of time, that part of the dumper touched 111 kV electricity, where also as a result, the dumper got electrified, and Sahanur Ali, who was inside the dumper cleaning it, died instantaneously on the spot due to electrocution. When postmortem examination on the dead body of Sahanur Ali was performed, at Morigaon Civil Hospital, it was opined that the cause of death was due to cardiorespiratory failure as a result of electrocution. In connection with the death of Sahanur Ali, a general diary entry by Kun Kusi Outpost, general diary entry number 108 and 124, where general diary entries were registered on 8/1/2019, and thereafter, comma, what is the full form of UD? UD case?
Unnatural death.
Unnatural.
A case for unnatural death was registered at Poitalangsu Police Station as UD case number 02/2019 on 9/1/2019. First off, from the contents of the general diary entry number 125, it is revealed that sorry, it was revealed during investigation that the vehicle, Winnipeg dumper, was being washed by Sahanur Ali, its handyman. So after completing washing of the inside of the dumper, Sahanur Ali lifted the body of the dumper in order to wash the out body of the dumper. At that time, the lifted body of the dumper came into contact with the overhead electricity wire. Also, as a result, Sahanur Ali, who was inside the dumper, was suspected died due to electrocution. Where the notification dated 15/11/2014 had provided for ex gratia relief mainly to persons, who were killed, stroke injured due to extremist violence, stroke terrorist violence, stroke acts of miscreants, stroke communal violence, stroke ethnic violence, stroke group case, stroke firing of security forces, stroke accident, etc., who were kidnapped, stroke abducted by extremists, stroke terrorists, stroke miscreants, and whose dwelling houses are fully burned, stroke damaged, whether due to acts of extremists, stroke terrorists, stroke miscreants, or during communal violence, stroke ethnic violence, stroke group case. Page 23. Full stop. On the under the head of accident, comma, provision has been made for execution relief to the next of kin of person killed due to accident in public places or in public carriers, within bracket, other than killed by extremist, stroke terrorist, stroke miscreant, and due to firing of security forces, bracket close, full stop. Unto. Because the public place has been defined. Public place has been defined এখন notification আছে.
Perhaps I have, can I,
Where is the public place defined? There is another notification.
yes, Lord.
Do we have that notification, Mr. Bhattacharya ji? Public place has been defined. এই এক্সগ্রেসিয়া 2 লাখ টাকার এটাতে আছে।
Yes. Public, there is a notice.
এটা বোম ফুটা যে আছে ঘৰত যে কিবা আইৰণ বল ফুটাই আছে যে তাতে লিখিছিলো just a management console. Vehicles of like person. এটাতে আছে ভিতর আছে, ভিতর আছে।
In that case, Lordship, it is defined, Lordship. In the case of Taslima Nasrin, WPC 4443 2021. ওটাকে হেতুতে ই করছে পাবলিক প্লেস ডিফাইন করা আছে। প্যারাগ্রাফ 12 চাই আছো একফালৰ পৰা চাই
As per Black's Law Dictionary, 10th edition, comma, page 18 or also. An accident, one, an unintended and unforeseen injurious occurrence, semicolon, something that does not occur in the usual course of events, or that could not be reasonably anticipated, colon, any unwanted or harmful event occurring suddenly, comma, as a collision, comma, spill, comma, fall, comma, or the like, comma, irrespective of cause of blame or blame, cause or blame. 2, an unforeseen and injurious occurrence not attributable to the victim's mistake, comma, negligence, comma, neglect, or misconduct, semicolon, an unanticipated and untoward event that causes harm, full stop. Accidental, the meaning of accidental is not having occurred as a result of anyone's purposeful act, colon, ESP, comma, resulting from an event that could not have been prevented by human skill or reasonable foresight. 2. Not having been caused by a tortious act. Full stop. Para. The facts disclosed by the petitioner and as revealed from the general diary entry number 125 dated 8/1/2019. It was the deceased who was doing the cleaning and washing of the vehicle at the relevant point of time. The deceased was the handyman stroke cleaner, was employed as a handyman stroke cleaner for the vehicle in question. Full stop. As a handyman stroke cleaner, he was not authorized to drive or operate the vehicle without any driving license. Full stop. The place where the dumper was parked, in the place where the dumper was parked, there was an overhead electricity transmission line. Full stop. The deceased, with reasonable foresight, had the disease exercised reasonable care and caution and exercise reasonable foresight, the event, the act of sorry, the act of electrocution could have been easily avoided. Full stop. From the materials on record, it is evident that the death of the Sahanur Ali was an unforeseen and injurious occurrence. Unforeseen was an occurrence, not attributable to any person other than the victim. Full stop. In an accident, accident otherwise means an event which takes place without one's foresight and expectation. Full stop. The date of the disease herein in the notification. The notification dated 15/11/2014 was issued for providing ex gratia relief to persons who are victim of the dates referred to in the case in hand, by no means can be brought within the purview of the notification dated 15/11/2024, 14. As in the considered view of the court, the ex gratia relief to the next of kin of a person killed due to accident in public places are meant for are confined to such dates which are attributable to the cause of which can be attributable to one other than the victim himself. Suppose in the event there was lack of reasonable care, caution, or foresight on the part of the victim, which led to his death, such a death is not to be one which would entitle the next of kin of such person to receive the ex gratia relief in terms of a notification dated 15/11/2014. Post of. In such view of the matter, this petition is found to be bereft of merit. First of it is, however, it is observed that if the date of the employees company. If the date of the deceased the dismissal of the repetition shall not preclude the petitioner to seek relief under, sorry. The, in terms of notifications also.
Lordship, liberty may be given for any other remedy.
Sorry, dismissal, sorry, and, sorry, do refusal to grant relief in terms of the notification dated 15/11/2014 would not preclude the petition to avail any other remedy for compensation in accordance with.
Lordship. Matsumi.
So obliged.
Item number 6. Lordship, in this case, I am appearing for respondent number 3 to 5. Lordship, although I have received instruction, but that is not complete. Lordship, I require another 4 weeks time to instruction and file.
May it please your Lordship, I appear for the petitioner, my lords.
Yes.
Lordship, they have sought time since June, my lords. Every time they seek time to file a reply. I have no objection, my lords, but not 4 weeks. Lordship may give them 1 week time because it's covered by several judgments of the several high courts, my lords.
Anyway, an interim order is operating.
Interim order is operating, lordships.
Mr.
Bharat Raichandani, lordships.
Heard Mr. Bharat Raichandani through virtual mode, along with Mr.
GK Dekar.
GK Dekar, learned counsel for the petitioner, and Mr. S.C. Kal, learned standing counsel, CGST, for the respond number
3, 4, and 5.
3, 4, and 5. Also heard Mr. H. Borwa, learned counsel representing Mr. P. Gugoi, standing lawyer, standing counsel, finance and taxation department. Some for the respond number 2. Okay. Each of which standing central government council for the respond number 1. Mr. Kyle, standing counsel, has submitted that though he has received certain instructions to file counter affidavit, the same are not complete. First of he has thus sought for further 4 weeks time to file counter affidavit of the respondent CGST authorities. The prayer is allowed. Release the case on so and so. The interim order past 3rd year shall continue till.
Grateful. We are
Finance Department.
Finance and Taxation Department. Finance Department. Okay, Finance Department.
12th December, 12.
Lordship, please. Grateful.
Item 7 and 8 for orders.
সাহেবটা হবো। No, 1 minute. হবো।
Item 7 and 8 for orders. My lord.
We have filed the requisition on the one issue. So our land is not demarcated. We approached the circle officer in 2012, not done, then ADC has made a survey. Circle officer has made a report says that the land is in under possession of other persons. They the private response. Then notice was issued to show them these documents, but that was not come to a logical end. In 2018, another notice is given, 13/2018, to demarcation and record correction. But they have filed a writ petitions, say, and stay order was granted, saying that two proceedings should not be, subsequent proceedings should not be made. Then we have also filed a writ petition 2021 for demarcation, and both the writ petition was disposed of in 2023, and says that since 13/7/2018 was, this order is vacated and demarcation process should be comes in logical end. With that direction, this was disposed of. After that, the demarcation was, the proceeding was undertaken, but surprisingly, our land was not demarcated. They demarcated one land, said that they are in possession, so that is why we have approached this, my lord. Now, my lord, we start.
Yes.
As per my instruction, my lord, demarcation took place. There is an old duct 202. Out of 202, there are 7 ducts. Ducts has been cleared out, man. So demarcation took place, man. Only I want to bring this on record, my lord. 1 week, my lord.
But it is already on record.
Already on record.
Already. I'm just placing, my lord. If my friend has finished, may I take your lordship? There were 2 writ petitions. Your lordship may turn to page 53 in WPC 5164.
আর এখন আছে নি?
It starts at page 50. WPC 516.
Yes.
My lord, this WPC 54449/2019, it was filed by me. The persons were Ashok Kumar Garodia and others. And my lord, at page 51, my lord, another writ petition filed by my learned friends, 7184221. Your lordship has got it at page 51. My lord, first of all, before going to that merit, I want to say, my friend's client are all power of attorney holders. The original persons who are aggrieved, they don't come before this. They are only the power of attorney. It is in the writ petition also. Now the observation, it takes place at page 53. My lord. May I read this slowly, my lord? Both the writ petitions taken up for disposal by this common order, taking into account the facts and allegation are interrelated. From the record, it is claimed that WPC 5449/2019 that the petitioner interest of the petitioner has purchased a plot of land by registered deed number such and such, measuring such and such, including height and such and such. The further record reveals that the proceeding was initiated by issuance of a notification under the provisions of Assam State Acquisition of Land belonging to religious and charitable institution by government notification dated 67. The resultant effect said notification reading the same in terms of Section 3 of the said Act of 59 and the definition of agriculture year as defining such and such would show that the notification can be effect with from 15/4/1967. Thereupon, this land covered by the Act number 25 old 202 new was settled with the predecessor interest in interest of the petitioner with effect from 544 in WPC number 5449/2019. It is also seen from the record that Act number 25 old and 202 new covered by Patta number such and such during the recent concluded resettlement operation began DAB number 2335.
Read slowly, sir. I don't understand. Paragraph 4. Paragraph 4. Read slowly.
It is also seen from the record of DAG number 25 old 202 new covered by Patta number such and such and such during the recent concluded resettlement operation became DAG number 2335 covered by Patta number 1400 of village Dwaranda. It also appeared that from the instruction kept on record and marked with letter X that this very dark number 2335 again partitioned among the petitioners in WPC 5449/2019, and thereby the petitioner number 123 were issued fresh patta bearing patta number 1675 and new dark became 265. However, as regards petitioner number 4, he was issued a fresh patta number 1674 and dark number 2657 new. In the backdrop of the above facts, this court takes up the writ petition number WPC 7184/21. It is his writ petition. It reveals that the plot of land measuring 4 bigha covered by dag number 205 of patta number 2 of the village Dwaranda under Moja Beltola was claimed to have been purchased by one Nepal Chandra De since decade. That is the father of the petitioner by registered deed bearing deed number such and such. And there was a mutation order 22/867 passed by the office of the Deputy Commissioner Kamrup Metro. It is not known as regards the exact quantity of the land in dag number 205. However, it is seen from the record that very dag number 205 during resettlement operation became dag number 2337, 2338, 2341, 2342, 2345, 46, 50, and 51. It is the further case of the petitioner in WPC 7184/21 that the name of the petitioner father was mysteriously removed from the record of right, and under such circumstances, an application was filed before the respondent authority. Be that it may, it is specific case of the petitioner in WPC 7184 that the said petitioner right is confined to dag number 205. The number is 205, my lord. And such dag number were carved out from dag number and not in respect of dag number 202. That is my dag number. And subsequently with dag number 2335 and presently number 2657 and 2658. In the above perspective, the court finds it relevant to take note of the challenge so made in WPC number 5449/2019, wherein the petitioners have assigned the notice 13/7/2018 issued by the Circle Officer Dispute Revenue Circle. From a perusal of the office to said notice, it reveals that in view of an application submitted by the father of the petitioner, late Nepal Chandra De, seeking demarcation of the land, the respondent authorities have asked the petitioner to appear before the said circle officer along with necessary documents. It is the opinion of the court that merely by asking the petitioner to produce certain documents by an authority do not require any interference. Under such circumstances, it is the opinion of the court that the question of setting aside the notice does not arise. The petitioner in WPC 5449/2019 would be well advised to place the relevant documents before the circle officer dispute revenue circle in support of the claim. Now coming to the writ petition number 7184/21, it is seen that amongst the relief which has been sought for, one such relief is that this court should declare the petitioner is the owner of dag number 205 in such Kheras Patta number 12 new in village Dwaranda under Beltola Moja, and that the respondent number 528 are the owners of plot of land measuring 4 bigha 3 kata 12 lectures covered by dag number 202 old. That is their statement. In Patta number such and such, in village Dwaranda Moja Beltola in the district of Kamur. In the opinion of this court, such a relief cannot be granted in a proceeding under Article 226 of the Constitution, and the petitioner, if he desires such a relief for declaration, the same could be done before the civil court. As regards the other two relief as sought for in the writ petition, it is seen the respondent authorities are already asking such action, and consequence thereupon has issued notice dated such and such, which has been put challenge in WPC 5449/2019. Under such circumstances, it is the opinion of this court, and as the matter is pending before the circle officer dispute revenue circle, the petitioner would be well advised to take appropriate steps before the said authority. I have heard Mr. H. Sharma, learned standing counsel, who submitted that the circle officer dispute revenue circle is taking steps in pursuance to application which has been filed by petitioner WPC 7184/29. It would bring the said proceeding to a logical conclusion after hearing both the parties. Taking into account the above, the court therefore disposes of both the writ petition with the following observation and direction. That the notice dated 31/7/28 WPC 5449/2019 is not interposed with and the petitioner would be well advised to approach the circle officer within Dispute Revenue Circle by placing the necessary document as sought for. The court is not inclined to issue any declaration as sought for in WPC number 718421. However, it is observed that the rejection of the said fare for issuance of declaration does not preclude the petitioner in both the writ petition to approach the competent court of law seeking declaration if need be. As regards the other relief, which would have been sought for demarcation as well as for correction of record, same being now be taken into consideration by the circle officer, Dispute Revenue Circle, this court direct the circle officer, Dispute Revenue Circle to bring the said proceeding to a logical conclusion in accordance with law within a period of 6 months from today. The registry directive, the court would, however, like to observe the land claimed by the petitioner in WPC 5449 arises in DAG number 202. Whereas the claim by the petitioner in WPC 718429 arises of DAG number 205, old. The court in the proceeding segments in the instant order has categorically mentioned the various DAG which are carved out of the above mentioned 2 DAGs. The circle officer, Dispute Revenue Circle shall duly take note of such deciding the said aspect. So my lord, my WPC was 55449 2019. They filed an application for demarcation, notice was issued. I challenged and it was declined. So, and I was directed to appear before the circle officer. And my position of DAG number was 202. And they have said this is my right. And they are in 205. We approach the circle officer. The circle officer order is under challenge in both the writ petition. The circle officer, which my friend Leoth Paul was placing, is also in record at page 79.
Go one by one after documents,
Mal,
after this judgment.
after this judgment, these are all the documents about my.
Let us have a look.
Mal.
Page 58
Notice.
is the notice
Notice.
by circle officer
Circle officer.
for appearance.
Appearing.
Then
Again notice.
again notice. Then
My lord.
authority for collection of map
Yes.
is 62. This is map.
My lord.
Annexer L is
My lord.
63.
Okay, my lord, map.
Who is the custodian of this map?
DLR.
DLR.
This,
We approached this DC, and DC has made communication to make available of this map. So we have collected.
Where part, in which part of this map these dark numbers are available?
My lord, 205, my lord, it is very, my lord, in page 64, my lord.
63.
My lord, it is, by that it becomes 2335. Our claim is that this is our.
Where it is?
Page 63.
North, south, east, west.
My lord, page 63, my lord, this is GS Road, my lord, and 2335 is evident, my lord.
No, I could not.
1054 is the road, my lord,
Right.
GS Road. And then, my lord, one land is 2335 is shown, my lord,
2335.
35. My lord, just right.
Big one.
Yes, my lord, big one, my lord.
Ah,
Left side, my lord.
this is new dark number of which one?
235, because this is.
1 minute, 1 minute. Two three five is 202.
They said the 202.
well, the circle
No,
officer.
they said no, it is already
Yes,
recorded
yes,
as judgment.
that is there. But original map, my lord, yeah,
That is not,
205 is shown, but that is why I'm,
that I cannot
Yes.
examine.
yes, my lord,
That I cannot examine.
that is. My lord, now, my lord,
Now,
Page-
let Mr. Roychodhuri.
My lord, your lordship then turn to page 79, the order of the circle officer.
but before that, my lord, page 65.
Let Mr. Roychodhuri, then you.
Yes, yes,
you
I
get the
will-
opportunity, please, sir.
Actually, my petition, I should have always, my senior will have that.
Page 79, the circle officer.
You know that if he makes some wrong
Yes.
submission, you point out.
Yes, yes, I will point out.
There were 2 writ petition filed, one 30.
Let us start the leaves first,
My lord,
one by one.
my lord.
Yes.
My lord, page
We
70
were up to 60.
page, my
We
lord,
are up to 60.
60.
Let us turn the leaves,
My lord,
pages. 62 also, 63, 64.
my
That,
lord.
what it is?
My lord, thereafter that translation were done and at page
Annex
60
M, what is this?
this is my, our names are there, my lord, in 2335. Name of the Pattadas, Rohitas Prasad Agrawal,
Huh? Page 65.
68.
65 is the amounts or the area of the land of the both two ducts, old ducts, my lord. 202 land is 14 bigha, 6 kotha, 7 lassa, and 205, 9 bigha, 2 kotha, 11 lassa.
Okay.
Before
Page
it-
60,
This was the position.
68,
Yes, my lord. 65.
68, yes.
It is
Yes.
our names are there, my lord.
68, my lord, their
Oh,
document.
both don't submit.
My lord. My lord.
You'll get the opportunity, I've said.
Yes, my. Okay.
Yes, 68, please.
My lord, your lordship will find name of.
How many in the other petition?
My lord, in this, my lord,
There are two parties.
Two parties.
One is Doyal Day.
the
In the other side,
other side, my lord, the petitioners, I am appearing for, my lord, Ashok Garodia, Santosh Garodia, Dilip Garodia, and Rohitas Prasad Agarwal has expired and his son has been respondent number 4, 5,
so
6.
these are Rohitas,
Rohitas.
Pradeep Kumar Das,
My lord.
he is not.
No, sir.
Pradeep Kumar Das, no.
No.
Ashok Kumar Garodia, how many, 3 or 4 or 5?
My lord, Ashok Kumar Garodia, Santosh Garodia, Dilip Garodia.
1
and
minute. Ashok Garodia, yes, and
Santosh Garodia, Dilip Garodia.
Santosh Garodia, okay, Dilip Garodia, and
Rohitas Prasad
Agarwal,
Agarwal.
4,
4, my lord.
okay. 1 minute. Yes.
Page 69, my lord, the remarks.
Huh. Yes.
My lord, as per order dated 15/5/2012, in mutation case number passed by circle officer, a plot of land measuring such a covered by Dag number in the name of Sri Rohitas Prasad Agrawal, son of Manchand Agrawal, to Sam Sundar Garodia, son of Rangmal Garodia, have been mutated by way of purchase and recorded collectively accordingly along with Pattarasi Pradeep Kumar Chandra Das, Robin Goswami, LR, Mohibul LR. For, as per order dated 10/10/2012, passed by circle officer in partition case, a part of land of this patta measuring such as covered by Dag number 2335 has been partitioned and recorded is corrected by creating new Dag number such and such, fresh patta number such and such, in name of Rohitas Prasad Agrawal.
1 minute. Yes.
Then, my lord, at page 70, in the name of Rohit Prasad Agrawal, the said correction is included in year 1420 Bangla. As per order, as passed in mutation case, land measuring R, which is a part of car, has been maintained in the name of Sam Sundar Garodia and Rohit Prasad Agrawal for road purpose. Then Kho, as per order 2012 passed by circle officer in partition case, land measuring such and such a part of Kho and land measuring such and such, total of 32.31 R covered by DAG number has been partitioned and recorded in is corrected by creating due DAG number 2568, page Patta 1675 in the name of Sam Sundar Garodia. The said correction is included in the year 1420 Bangla. As per order 10/9/21.
Oh, how it is telling with the judgment?
My lord,
How it is telling with the judgment?
my lord, the judgment before that, my lord, these documents they have given in their writ petition. They have passed in this writ. They have given, it is not my writ. They have given. And thereafter the circle officer.
Because it is not telling with the judgment.
My lord.
These DAG numbers, 2568.
My lord.
2568. It is 2658. We don't know. 167. Something is wrong. Translation is wrong or something is wrong.
Everything will be clear, my lord, from the circle officer order.
25. This is wrong. Page 54. Fourth line.
No.
New DAG became 2658. This is wrong.
That
Please come to page 54.
2856.
1 minute.
2856.
1 minute.
It should be 2856.
2856, my lord, please.
It should be
2856.
No,
Five, four, and
don't think. I don't think.
Page 50.
If you come to page 72.
It should be, my lord, it would be 2658.
2568.
My lord, 2658. It
No.
will, my lord, in the
If
order.
Jamabandi is correct.
My lord, because your lordship will find.
If Jamabandi page 72. Don't go to the translation.
No.
That is carelessly done.
My lord.
If you can read Assamese, read.
My lord, my lord.
Kho.
Kho. Kho. পাটৱাৰা ইমান গছৰ ওপৰত দিয়া বিক্ৰয় বিষয়ে মহোদয়ৰ বাবে হুকুমত পাট্টা 2335 নামত দাগৰ ইমান অংশ আৰু খ ইমান অংশ জমিত অমিত 1675 নামৰ পুক্ষ পাট্টা 2568 নামৰ পৃথক দাগ শ্ৰী শ্যামসুন্দৰ
Remember 2568.
2568.
Come back to 54.
My lord.
Thereby, second line, thereby the petitioners,
My lord.
number 1, 2, and 3
No.
were issued face patta bearing 1675.
No.
Right?
My lord.
1675. And new DAG became 2658.
My lord.
Come back to 72. It is 2568.
2568. Well, that may be a typographical regarding 26 and
But all these are these are comparison.
comparison.
DAG numbers and patta numbers comparison.
My lord,
Nothing.
no, my lord. After that, there was a field survey and the circle officer passed an order. That is in, my lord, your lordship will find in page 79. This is the order which is under.
No, what I am pointing out that this creates.
Then there was a field survey, every document was placed and at page 70.
Then let
Page
us,
79.
let us have. Okay, now what is this?
My lord, this is the order in pursuance to both the writ petition, which
Last
is under
page number 79.
79. CR is put up today. Since the peruse the order of the Honorable High Court Guwahati in WPC 5449/2019 and WPC 7184/21 dated such to bring the said matter to a logical conclusion, considering various DAGs which were carved out of old 202, old 205 in the matter later dated such and such from Additional District Commissioner directing Circle Officer, Dispute Revenue Circle to take necessary action. Following this, hearing date were fixed on 3/4/24. Both the parties were heard on the aforementioned date. Doyle Chandra, represented by his power of attorney holder, Bishwajit Borua, son of late Manik Chandra Bora submitted following documents during the course of hearing in favor of title over the disputed land pending for demarcation. Deed bearing serial number 4941 dated 16/3/66 between Bosishto Devalai, represented by Sanatan Sharma Doloi and Nepal Chandra De. A copy of Saddar Jamabandi by Nisib Khesar as Patta number 7. A copy of draft Jamabandi for Dag number 205. Copy of old trace map marking old Dag number 205. Copies of old revenue receipt. Copy of letter to Deputy Commissioner dated 10/1/2013. A copy of notice by Additional Deputy Commissioner to Sam Sundar Garodia, Rohitesh Prasad Agrawal. Copy of demarcation notice by Circle Officer, Dispur Revenue Circle, dated 13/7/2018. A copy of RTI dated 22/12/20. A copy of power of attorney dated between Dal Chandra De and Bishwajit Borua, Ranjan Gogoi and Hemanta Kumar Das. Opposite party, Ashok Kumar Garodia and 3 others have submitted the following documents during the course of hearing. A copy of deed serial number 4597 dated 6/7/1962 between Bosishto Devala, represented by Sanatan Sharma Doloi, Rohitesh Prasad Agrawal and Sham Sundar Garodi. A copy of letter by Settlement Officer, Guwahati, to Secretary, Department of Revenue regarding settlement proposal. A copy of settlement approval letter by Department Secretary, Revenue Reform Department. A copy of death certificate of Sham Sundar Garodia. A copy of certified copy of Jamabandi dated 15/12/25. A copy of Patta, a copy of Jamabandi, a copy of Chitta, a copy of trace map, a copy of power of attorney between Rohitesh Prasad Agrawal and Sunil Kumar Kejriwal, deed number. Rohitesh Prasad and Sunil Kejriwal are father and son. Father was ill, so Sunil Prasad Kejriwal there. In page 81, number
Who?
10.
Rohitesh Prasad Agrawal
And Sunil Kumar Kejriwal. Sunil Kumar Kejriwal is the son of Rohitesh Prasad Agrawal. Now he is present. He is there as a party. A copy of old trace map, a copy of draft chitta, a copy of circle officer, Dispute Revenue Circle report dated such and such, a copy of notice dated in demarcation case. On perusal of careful examination of documents submitted by both the parties, following facts has come to light. Deed number 4941 dated 16/3/66 between Bosishto Devala, represented by Sanatan Doloi and Nepal Chandra De, is for land measuring 4 biga covered by Dag number old 205 with a condition. A pattar মেয়াদ আজি 16/3/66 হনৰ তাৰিখে 99 বছৰৰ নিবাৰণ লৈ বছৰৰ কাৰণে বলত থাকিব। Next, a copy of deed serial number 4597 dated 16/7/62 between Bishwajit Devalai, represented by Sanatan Doloi, Rohitesh Prasad Agrawal and Shamsundar Garodia, is for land measuring 4 biga 3 kata 12 lashes covered by Dag number old 202 with a condition. A pattar মেয়াদত 1962 চনৰ 1/7/62 চনত তৰঙৰ পৰা 20,061 চনৰ 30 জুন পৰ্যন্ত 99 বছৰৰ কাৰণে বলবৎ থাকিব। A correction of mutation order reflected in Sadar Jamabandi of Nisib Kheraj Patta number 1 in as furnished by Bishwajit Borua. Bishwajit Borua 2 নম্বর অংশৰ খেয়াদ 447 6768 নাম্বার মেয়াদ 22/8/1967 তাৰিখৰ মতে এই পাট্টাৰ 205 নম্বৰ দাগৰ 4 বিঘা জমিত খৰিদা হুত্ৰেসী নেপাল দে আৰু পিতা মুনিন্দ দে পাট্টাৰ লগত নামজাৰি দিয়া হ'ল। এই ভূষ্ম বৈশ্য সাজ। A copy of government letter dated 21/11/95 from Department of Revenue to Settlement Officer as furnished by OP, opposite party. Land measuring 4 biga 3 kata 2 lectures covered by Dag number 202, which was obtained for 99 years lease by Bosishto Devala, was acquired under the provision of Assam State Acquisition of Land belonging to Religious and Charitable Institution of Public Nature Act 1959 as per government notification such and such dated. In the same communication, that land measuring 4 biga 3 kata 12 lectures covered by 202 Dag old was settled to Sham Sundar Garodia, Sri Rohitesh Prasad Agrawal on realization of premium, and settlement officer was directed to correct the records accordingly. Therefore, it is apparent from the fact as stated above, the Ashok Kumar Garodia and 3 others have claimed title over land in old Dag number 202, whereas Bishwajit Borua, attorney holder, is claiming title over land old 205. Hence, to ascertain whether the disputed schedule of land on field belongs to old dark number 202 or 205. A demarcation in presence of both the parties need to be carried out as to bring out the matter to a logical conclusion. Accordingly, a date was fixed on date 9/4/24 for demarcation of the disputed land. However, the same could not be carried out on the day fixed date as both the parties prayed for another day as per LM report signed by both the parties. Again, another date for demarcation was fixed on 17/5/24 at 11 AM. Notice for demarcation was duly served. Concerned parties Sunil Agrawal, Santosh Garodia, and Vishwajit Borua were present at the site of demarcation on 17/5/24. Peruse the demarcation report submitted by the concerned lot mandal. The measurement has started considering the reference point at D as indicated in the trace map and field book, which is the start point of land to be demarcated. The measurement was taken till the point A as indicated in the trace map, dark number 2308. The measurement has been plotted on paper, and trace map was also prepared. The field measurement has been tallied with the revenue village map. It is noticed from the record available that new dark number 2658 and 2657 was carved out from the old dark number 202, whereas the new dark number carved out of old dark number 205 are 2337, 2338, 2341, 2342, 2345, 2346, 2350, and 2391. The measurement found on field as reported by lot mandal has been tallied with measurement found on the map. Both the measurement found matching with each other. Again, measurement has been taken till other end point of village, reference point F, as can be seen at the trace map. And the measurement on field as reported by lot mandal has been tallied with the map, which is found matching. The entire exercise infers the disputed land claimed by both the parties on field belongs to dark number 2657 and 2658 of patta number 1674 and 1675 respectively, which is a part of old dark number
Yes.
Old dark number 202 of revenue village Dhoranda. The pattadar recorded in these two darks are namely Rohitas Prasad Agrawal, son of Mamchand Agrawal, Ashok Kumar Garodia, Santosh Garodia, Dilip Garodia, all son of late Swami Sundar Garodia under their possession. Whereas on field survey, it has come out that dark number 2337, 2338, 2341, 2342, 454650 were carved out from old dark number 205, where there are other recorded pattadars who have possession over the land. No part of dark number belonging to old 205 dark is under possession of Ashok Kumar Garodia and three others. That was the finding. We are not in their possession, in their land. The records available and the result of demarcation indicates Shyam Sundar Garodia, Rohitas Prasad Agrawal, and got settlement of old dark number 202 of village Dhoranda for an area such as 4 biga 3 kata 12 acres and have current possession over it. Whereas Vishwajit Borua, attorney holder, submitted a deed such and such indicating Anisif Khesara's land on measure to Mr. Nepal Chandra De, son of at old dark number 202, in which Nepal Chandra De or his legal heirs or attorney holders do not have possession over it. Hence, the demarcation schedule, which described trace map as belongs to dark number 265 and 265 number, old dark number 202, which is under possession of Ashok Garodia and three others, and recorded pattadars of the said dark. The land measurement is given, and next draft report of the onward submission to the higher authority. This order has come to be challenged in writ petition. The basic thing is this: these persons are constructing over a plot of land. Earlier, they came with a writ petition. When this order was passed, they did not inform the court and came with a prayer, stop the construction. This was on apprehension that they are not passing the orders. Your Lordship will find.
No. Let us, this repetition which we have read now, are whose repetition?
Malab, this is 5161.
By whom? This is.
This Doyal Chandra, then
Doyal Chandra.
And
Okay,
both the
Doyal
writ petitions
Chandra.
are filed by them, Malab. One on apprehension, one on.
This is now, let us understand. What is the prayer in this writ petition?
To set aside the circle officer.
This order is dated what?
1/6/24. 1/6/24.
2024. Okay. One thing from this page 84, it emerges that this Rohitas
Correspondence.
say Syam Sundar Garodia land is adjacent to, in the southern side, 2346, 2342, 2337. Have you understood?
No. Page 84.
7 Dag numbers were carved out of Dag number 205. Right?
This is.
Right?
Right.
Page 84.
84.
Second para. It has come out. Whereas on field survey, it has come out. Dag number 2337, 2338, 2341, 2342, 2345, 2346, and 2350 has carved out from old Dag number 205.
Which is our.
It is an admitted position. Now come to the boundary of Rohitas and Samsundar's boundary. It is land measuring last para. And the demarcated schedule of land with description as below belongs to Dag number 232658 and 2657, old Dag 202, which is under possession of Ashok Kumar Agarwal and 3 others, and are recorded patadas of said Dag. Now, if you compare on the sounded boundary, is 2346, right? 2342 and 2337. These 3 Dag numbers, property belonging to old Dag number 205 is on the southern side of the boundary. Other 3 sides clear. There is no contact with 202 and 205. Right? Only on the southern side of Rohitas, it is there.
So
Now,
they have joined hands to construct in that plot of land.
now this is regarding setting aside of that report. The other repetition is also by Doyle Day.
My lord,
Okay.
he came with the apprehension
1
that
minute.
to stop construction.
When 6 months pass, no result comes, then under apprehension, they are started construction. So repetition file in the pendency, they have report is given. That is why. new
No,
cause
my
of
lord,
action,
no,
new
this is-
job action, then new second repetition.
This writ petition was filed on, my lord, I will place that, my lord. Both, it was filed on 12 June 2024. And my lord, the report came on 1/6/2024.
was-
And both the parties were present in the
Not-
report.
And not communicated after RTI, my lord, or lot of persuasion we able to.
You should for restricting for clear construction work either on land covered by Dag number 205 or covered by Route 2 till the demarcation proceeding is concluded. Commanding responsibility is given to include land covered by so and so with as directed by so and so. Cancel NOC planning permit after hearing the part. Written respondents. Signatures stop the unauthorized construction work carried out by private respondents. This Vishwajit Borua is a builder.
No, my
No,
lord.
my lord. We are the builders, my lord, in the name of Green Tech. My lord, they want, my lord, lot of power of attorney holders are filing civil suit, these writ petitions, only to just, my lord, because even civil suit is pending,
No,
The-
no, merit is not, I am just asking.
And we are the builders and we are these persons are the owners of the plot of land and given to intake to.
He is represented by Biswajit Borro, attorney holder, my lord.
নথি শুধৰণি
Nepal,
আবেদনকাৰী চক্ৰ বিষয়া
আমার আগৰ
These power attorney holders are also proclaimed to be builders. Development agreement.
in earlier this petition of theirs, my lord, I found the power of attorney.
No, it is there. See this power of attorney.
Yes, I have an next.
That is at page 38. 38, it is there. Nepal Sondode in respect of development of scheduled land by registered deed of agreement number so and so, 2020. So development agreement, development project.
My lord. The lordship permits me to say one thing.
1 minute.
এই মিসকেসটো যে ভিডিও আছে কোনটো আছে নিছে
So first writ petition,
Page 60, my lord.
3090/2024 was filed on the ground that demarcation proceeding was not completed.
And this,
And development works
Was
or constructions work carried out by the private respondents should be stopped, right? Now here, there are two ducks involved, 202, 205. 202 is by Rohitas Agarwal and etc. And 205 by Doyalde, right? Rohitas Agarwal etc. They are in 202. So whatever the dark numbers, pattern numbers, it is clear. And total land is 4 bigha, 3 kotha, 12 lesa. So far as dark number 205, Doyal Sondro, Nepal Sondro, it had 4 bighas. During demarcation proceeding, this Rohitas, etc., was found to be in possession of the land
owned by Nepal. That is why the report, pace. And that is why they are called for to show
First,
how they.
let me complete. You say 3 words, I'll interrupt.
No.
I say 3 words, you interrupt.
No,
And PK Roychaudhary will interrupt with 3 words. And it's gone. Record say, this order says that the persons who claim ownership of DAG number 202 or subsequent DAGs and pattas, they are in possession of 4 bigha, 3 katha, 12 desa. That is the report. If we are not field verification team, don't compare with us, right? And on the other hand, the report says that in DAG number 4 bighas, which have been carved out into 7 more DAG numbers subsequently, right? And these Doyas on the day are found not to be in possession, or his attorney owner do not have possession over it. Page 84. 84. Page 84.
84, I got my.
Right?
Yes.
That is the finding recorded. 202 and 205. Subsequent DAG numbers, pattern numbers, there is no dispute. I think it is telling. Actually, few typographical mistake. Out of 205, 7 DAG numbers. Out of 202, few DAG numbers, pattern numbers, which Rohitas, Samsundar and all, they are found to be having possession. So ownership and possession are found telling, as per the report, in case of Rohitas, Samsundar. Right? In case of Doyal, ownership is found telling, maybe, but possession is not. Sum and substance is this
One thing.
or not?
One
If-
thing why
if I
like,
can say, my lord.
whole crux of the matter is that a 67 mutation was done. He was paying revenue. 87.
We don't, we are not into it.
After resettlement operation, his name was on the records.
In
Records?
In
So-
Records may have.
Somehow it is corrected.
One is
Mr. Borua, I on my own,
what he says, my lord.
in the record,
This is the report of this.
possess about 40 bighas in my village,
My lord, under the,
but I don't have the possession.
My lord.
my lord, under 1962, under the Charitable Institution Act, on premium being asked, we have been settled in 62, and he claims land over that as a ownership in 67.
No, ultimately it is found to be 202 and 205 are 2 separate DAG numbers with separate areas of land.
Land,
Am I correct or not?
correct.
So both lands are in existence separately. One is 4 bigha,
Yes.
right?
Yes. One is 4 bigha, 3 kotha, 12 lakh.
4 bigha, 3 kotha, 12 lesser. That is dag number 202. And they are in the name of Rohita, Samsunar, etc. Right? The party B. Party A is Nepal
Yes.
or Doyal.
Yes.
He claims ownership in dag number 205, which has been carved out into 7 more dag numbers. Admittedly. And 205 had 4 bighas of land. Right? Now, as per the field verification report, come to 84. Whereas on field survey, it has come out that dag number, 7 dag number, has been carved out from old dag number 205. Where there are other recorded patadars who have possession over the land. No part of any dag belonging to old 205 is under possession of Ashok Kumar Garodia and 3 others. This is field verification. The records available and results of demarcation indicates Shyam Sundar Garodia and Rohitas Prasad Agarwal got settlement at old dag number 202 for an area of 4 bigha, 3 kotha, 12 hesa and have current possession over it. Whereas Vishwajit Borua indicated Niskira's land on lease to Nepal Chandra Dey, old dag number 205, in which Nepal Chandra Dey or his legal heir or attorney holder do not have possession over it. Hence, right, demarcated, this part is regarding 202 boundaries. So this finding regarding 202 and 7 dag numbers carved out of it, this Doyal or Nepal or his legal heir or attorney holder do not have possession over it. Then it says that other recorded patadars who have possession over the land. But those patadars are not Rohitas or Shyam Sundar.
No, Ashok Garodia, man, we are
Ashok.
Ashok Garodia.
Whoever, party B. There are 2 persons, 4 together. I don't remember. 4 together on one side. Nepal or Doyal is on the other side. That is the crux of the matter.
Crux of the matter. Mala, that is, yeah.
Oh, that's all. Team A and Team B.
Team B.
That's all. Now, so far as 4 bighas of land, under dag number 205, 7 dag was created and there are found recorded patadars who have possession over the land. And you do not have the possession over the land. They have their possession over their 4 bighas so and so land. Right? In that case, there is a fact-finding inquiry. How you are challenging it? Because we do not sit in appeal. If somebody else have possession over these dag numbers, then for restoration of possession, it is civil suit. Or if you want to challenge it, you challenge it before appeal.
Deputy Commissioner, DC, under 140. Appeal before the DC.
We do not enter into, we simply say, we do not enter into fact-finding inquiry. The Deputy Commissioner has the power again to revise and to order demarcation. Face demarcation, whatever. But we do not sit in appeal and appreciate whatever is the finding in the fact-finding inquiry report. So how do you challenge it?
Yes.
Factual determination we are not going to enter. And it is evident that you do not have the possession. And read code do not hand over possession.
Declaration.
No declaration, no handover possession.
That is correct.
And somebody is encroaching, you have to evict them by civil suit. And if you are finding fault with this fact-finding inquiry report, you have to appeal before the Deputy Commissioner and Board of Revenue.
My lord.
Right.
My lord, yes, my lord, I understood the points. My lord, thing is that, my lord, here, they have not filed for demarcation. They have filed writ petition to stay the demarcation. We have filed the case for demarcation, writ petition, but it was disposed
We
of.
are dealing with two writ petition filed by
Yes,
Doyle Sondre
but
Day.
demarcation of 205. Demarcation means for corners of 205. It may be in their possession of some others, that is a civil matter. But this 4 biga is east, west, north, south, not in the possession. That was not done in this report.
Which one?
205, because there is a clear direction that you demarcate 205, it is separate from 202. So,
See, when something is under possession of others,
yes,
those are not to be demarcated. I have held so.
my lord, there is a.
Suppose your neighbor, Mr. Borua,
My lord,
your adjacent neighbor,
yes, my
if you claim
yes,
that my land is enclosed by this by putting boundary wall,
yes,
then circle officer cannot go and enter into his house. He can only find out the area under your possession, within your boundary wall. This is the boundary wall. If you are in possession of this, you say, I claim ownership of 205 and it has 4 bighas of land,
correct.
right? He will demarcate the area under your possession, and if he finds that no, instead of 4 bighas, you are in possession of 3 bighas and remaining 1 bigha is in possession of others, he cannot go there and demarcate your land.
My lord,
Then it is a matter of civil suit.
my lord. Regarding the demarcation, my lord, okay. Yes, yes, my lord. I'm coming, my lord, kindly. This code, there is a office memorandum and there is a statutory provision. When circle officer was
Some
approached,
land and revenue regulation.
before that,
Where is the demarcation provision, Mr. Das? Any provision is there?
my lord.
These land matters.
Circle officer has a duty to keep the boundary, whether it may be other possession or possession of others, but when there is a direction and he has a duty of
1 minute.
statutory provision is not.
In the course of survey, it has come to Section 23.
So we want to say.
Section 23. Right.
Yes.
Procedure in case of boundary disputes. When the course of survey it comes to knowledge of the survey officer that any boundary dispute exists, he shall notify the same to the settlement officer, who shall proceed as follows. If the dispute is between the proprietors of different estates, the settlement officer shall decide it on the basis of actual possession. And if he is unable to satisfy himself as to which party is in possession, he may determine by summary inquiry who is the person best entitled to possession, and may put him in possession, or he may refer the dispute to arbitration for decision on the merits. If the dispute is between settlement holder or different estates, the settlement officer after due screening determine the proper boundaries of those estates. And if the dispute is between government and any settlement holder or any so and so, after due can determine the dispute. So it is in actual possession which can be determined. He cannot enter into boundary dispute.
All right, we have no possession, we are, but
Now, your office memorandum.
my lord,
Your office memorandum. Yes, please.
May first.
Ah.
Is repetition.
No, your office memorandum.
Yes. I just want to say that circle officer has some duty. And if not, so it is 226.
Let us read.
Section.
Hey, Riju Prasad Sharma.
Service name. Demarcation shot.
Yes,
Oh,
office memorandum.
yes, ma'am.
What do you want to show? Service name, demarcation certificate, where there is no dispute on title.
Yes. There is no dispute.
No dispute title. Then imported service.
Yes,
Is the issue of demand, this service is required to establish the real extent or interest of the land
yes.
and establish the actual boundary of particular dark as per cadastral map of revenue. This service can be obtained. Now I have said that only this much can be demarcated, which is in the actual possession of the applicant. I have held so.
There 202, we have no dispute about that.
I have held so.
205, my lord, it should be like that, the 205, we have demarcated this boundary is this, but this is under possession. Why that part is absent? Last 2 decades, my lord, they are not demarcated the land. That is why this honorable court says that this comes to a logical land. If possession, our land, they are in possession, we should have a civil suit, that is other, but we should know the boundary. And this is the specific direction of this honorable court as well as, but this is the boundary, but you are not in possession. You should go to other courts, other. But why they are side away to demarcate 205? That is a big land, 4 bigger, where it's gone? It's gone to some other, there through any transfer. That should be clear.
23. Yes, Mr. Das, do you have any decision on section 23?
There are 80.
Huh? Which one?
It's alternative remedy and public service that your lordship.
No, that is a different thing, but section 23.
No, I have.
That demarcation, basically,
But
that
Yes, I.
only that much can be
No,
decided, which on the basis of actual possession.
actual one.
That part. I think that that is it. Or it's at any decision in 23.
One thing that I want to point out, my lord, if I may. Page 68 of 5.64. There, my lord, documents, land documents, which was also they relied upon in their miss case.
So far, see, Mr. Borua, so far, which land, which DAG number and which Pata number are recorded in the names of the two parties are already decided in the earlier round.
Not decided, they have direction that you
Oh, Mr.
this things, conclude this, that 205.
No, Mr. Then you should have,
And
check-
record correction.
Mr. Borua,
My lord,
come to page 53.
my lord. And the record correction part is also there because mysterious.
Record correction is different thing.
Yes. 53, my lord.
First, it is the title
Yes,
and ownership. As per paragraph 3 and paragraph 4
my lord,
and paragraph 5. Right?
my lord.
That you are owner of Royal Sondodek had title of 205.
My lord,
They had the title of 202.
My-
All are recorded.
recorded. No dispute.
Paragraph 2, 3, 4.
Yes,
Now the question is, next is possession.
not demarcation. Position may be there, but we should identify our land because after resettlement, suddenly our name was deleted. We are not allowed to give the revenue. Then when we show our land, they said that no, this is not your land. So where is our land?
Demarcation. Demarcation was done.
Done in respect of 202, their boundary is given.
Right.
205, they are silent. They are still. not-
205.
Yes.
Now nobody had the owner does not have the possession.
Possession is all right.
It is recorded.
My lord,
It is recorded in the fact-finding inquiry report.
I understood, my lord. I admit that. but
And in that case,
my lord,
whether it is possible for the circle officer to demarcate.
my lord.
This is the only issue.
Issue one.
Your only grievance is that your
Land is
205 is not demarcated,
And record.
right?
And name is.
As per the inquiry,
Yeah.
others have possession over it,
Others
and you don't have.
And when it's 4 bigha plus land, old lands are there, my lord. I can show. So in that land there. but
I have no doubt about your ownership.
My lord.
As I said already, I have also title and ownership of 40 bighas of land
My lord.
in my village,
My lord.
Position with them.
but I do not have the possession.
My lord.
My lord
But
has
your lordship name
constructive
should be
position.
revenue.
My lord has constructive position. They
Titular.
There should be a name.
There is a word called titular,
My lord, we have,
right?
my lord.
Sometimes the king is placed,
My lord.
but prime minister or earlier times runs the entire administration. Then this king is called titular king. So Nepal or Doyal is a titular owner.
They also titular owner. I can show that page 68 kind.
Oh, they are titular owner as well as they have the possession.
I have serious doubt they have got settlement or not. I can establish this.
So then you challenge it before the appropriate
No,
appellate
well,
forum.
page-
Why you are challenging this in?
My lord,
Tell me.
with more humble.
If
One submission, my lord, humble submission. If you are
okay,
owner-
we'll hear you again at
Yes.
2 o'clock.
prayer, my lord. For item number 9, my lord, can it be taken up next Thursday? My lord? Please for the other side.
What?
Item
9.
number 9, my lord.
What is the issue?
Look, this is regarding the bringing the supplicant association under the purview of the RTI. The case.
I think that has been, I think now has been, there is an act.
So in fact, my lord, the matter is quite different. In fact, the CIC had already held that the the CCI is under the.
But the parliament has enacted an act. Have you seen it?
Whatever.
Don't know. Google it.
The next Thursday, my lord.
No, I'll not fix it next Thursday. Cannot go on fixing. After a week, on the prayer of Mr. R.D. Learned Counsel for the petitioner. Release the case after a week. Miss
N. Upadhyay, ma'am.
and Upadhyay Learned Counsel for the
Respond number 6.
6 is in attendance. First of the question here, the issue raised here in whether BCCI comes under the purview of the right to
ACA, Cricket Association.
ACA. Okay, ACA comes within the purview of the
RTI.
RTI Act. As sought for by the and agreed to by the Learned Counsel for the party, list. Huh? If BCCI goes out of RTI,
And go. That is the case, my lord. In fact,
it is going out of the RTI Act. That is a strange thing. Everybody is questioning it. But by the parliament, they react, all other national bodies have been brought under the purview of. There is a discussion going on, but BCCI is out.
Obliged.
So, is there any procedure laid down regarding demarcation in the rules? So court by the earlier direction gave direction to demarcate the two plots of land, 202, 205. So what does the demarcation exercise envisages? Mr. Das? Is 80? Yes.
Certain the whether this of the land or field belongs to all log number 5 field demarcation in the presence of both parties carried out. So as to bring to the matter to a logical conclusion.
Hmm.
Next phase. Piece of demarcation has been duly served. Concerned parties, namely Lagarota, Santos Garotia, on the date of 7/5. Peruse the demarcation report submit. Demarcation took place, and there, my lord, mainly agreed saying that 205 has not been demarcated.
Measurement has been started.
But the
As indicated, trace measurement the start point of the land to be marketed. Taken till as indicated in month. Dark numbers, so. Measurement plotted on paper, maybe also.
is it? Oh my.
It has been noticed from the records available. Carved out from the result not filled. We telemeter measure. The measurements. The measurement.
Here, he agreed is base 84 para 2. There is a field survey. It has come out the dark number 23728014546. Out of the dark number 205. Where there are other record patterners who have for the land.
Whether this part of the demarcation exercise
Yes,
is in conformity with the direction in the repetition.
Yes, my lord. No part of any dark belonging to 5 is under the position of Ashok Bhagarwat.
That is,
My lord, it has been.
that is regarding possession.
Yes, my lord. It has been
But demarcation of 205.
Yes, my lord, it has been demarcated. That's why they came to know the possession, my lord. Either this or that part. My lord, the next paragraph is also very much clear, my lord. The records available and the results of the demarcation indicates that Syam Sundar Garodia, result of demarcation indicates that, my lord. So, my lord.
The third paragraph,
My lord.
hence the demarcated schedule of land with description
Yes, my lord.
as below.
Yes, my lord.
Like this, the demarcation of 205 was not done.
But para 2 is very much clear, my lord.
No, demarcation means defined boundaries. Like 202 old dark number. That is not done.
The
For
records available in the
205.
results of the indicated Syam Chandra Agarwala, Rohita Sagarwala, both settlement at all number 12, whereas Biswajit Bora, attorney holder by deed number on the land leased to Nepal Chandra Day at all dark number 205, in which Nepal Chandra Day or is legal, there do not
Not
have
have
position.
possession, but demarcation.
But that is my lord, they'll have to look the position, then only it can be demarcated. my lord.
No, whether.
Yes, it is a fact, my lord. It's not reflected in the order
Yes.
sheets. The, as mentioned, the land.
Like
measuring-
202.
Yes, 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 yes. That is not
Demarcation
reflected.
of 205 is not done.
Yes, no, it's.
Even if
My submission,
seven dark numbers, seven dark numbers. 205 has been carved out into seven dark number. May have different parcels of land as per the revenue records.
Yes.
But demarcation means the four boundaries. This side, that side, that side, that side. North, south, east, west. Thereafter, the question of the possession would come.
my lord, with regard to this, my lord, hence demarcated scheduled land with description. With regard to 202.
Only 202.
My lord, yes. Yes, my lord, it has not given any specific with boundaries, my. That's not reflected, my.
Thereafter, possession for restoration of possession, eviction, he has to go for civil suit.
My lord, yes.
If somebody is in possession of 205.
That's true, my lord. Your lordship also is very much correct. But my submission would be, my lord, they are
But
challenging.
where is the, because direction is for both.
My submission would be, my lord, they are aggrieved by this order. And by according to this, my lord, and then appeal lies before the DC, my lord. They are not filing the case for non-compliance of the earlier order, my lord. They are challenging the order passed by the circle officer with regard to the demarcation, my. And my submission would be, my lord, and appeal lies, my lord. Had there been a case of non-compliance, I could have.
Presence of alternative remedy of appeal. Now this, you have to see, these are pending before this court. It is not that the exclusion of writ remedies.
I'm not into it, my.
Right. That is available. But on the face of it, the direction made in the order for demarcation,
But the
which
demarcation.
you have done for 202.
No, no. 205 also have been done, ma. My submission.
Where is the reflection?
Yeah, it's not been reflected, ma.
My friend,
Something is in the mind, not in paper.
from the.
Does not
report
serve any
itself,
purpose.
From the description for the land which has been taken as X to F. That it is there from X to F. It is there in the order.
Not satisfied.
But one thing that I want to place before your lordship to the.
Boundary demarcation for 202 is done. And they have found also that there is possession. So far as boundary demarcation of 205, that is not reflected.
One thing your lordship will find, your lordship promise, their whole case on the basis of a lease given by Devattalaya, the Vishishta Devalaya in 67 on a allotment basis. Not on, they don't have any ownership, nothing. Their document, but I'm placing before Lord.
That is not, we are into that direction.
But because
We're not
any
deciding
ownership.
title now.
They don't have any ownership, no possession. It is only for the harassment.
205, it is, you should have said.
Because but they 205, they don't have any right about it, man. Their document.
Mr. Roy Chaudhary, this we are only pursuant to the direction made in the order dated 17
Well,
to
the record-
2024. The direction is for demarcation of 202 and 205.
Le-
We are into very simple logic. While undertaking the exercise, you have defined the boundaries of 202, right?
No.
North, east, south, west, clearly defined. Where is the reflection of about 205? That is the grievance only.
My lord, your
You
lordship-
mark, demarcation means you mark the boundaries of 205.
my lord, your-
And you have done in a specific manner for 202. Why not 205?
well, there is a line, no part of any dark belong to old 205 is under position of.
No, that is
My lord,
one, Mr. Roy Chaudhary, one is demarcation.
no,
Then thereafter, he may say about possession.
no.
But demarcation of 205 and 202 are the directions.
No.
That was the direction.
No.
For 202, it has been done in specific manner. These are the specific boundary, west side, east side, north,
Can
south.
I make one submission if you lordship? The records for which, under which this order was passed will reflect whether from X to F, which has been taken care of, includes both 202 and 205. Because
What
they-
is not done?
the record will say,
There must be reflection in the record.
my lord, that record has to
That
come.
order.
My
Where
lord,
is that?
my lord, it itself shows, my lord, your lordship will find.
No, I'm not satisfied.
My lord, another one thing, my lord, your lordship.
Demarcation is one, possession is another.
My lord. My lord, in your lordship.
Even if there may not be possession, the direction is for demarcation.
Page 35, your lordship.
Do
will
it.
find. Page 35 of the, my lord, your lordship will find their whole case, 5164. The original, they have annexed, that is it, page 36. This, what they are,
We are not into documents, sir.
my lord, they are just to harass this. We have been,
No. We are not. I'm not buying that.
because here, my lord, it is only. a-
Direction is why you have done it in favor of the 202. Why not 205?
My submission will be my, demarcation has been done, but it is not reflected as reflected.
So it is nothing. It amounts to nothing.
But one more. Then this report my. Is it not for the non-compliance of the earlier? Here is challenging the specific order of the.
This order
circle
and
office.
this order flows from that order.
My lord, that order which reflects is Roman page 56, Roman 2. Roman 2. My lord, what the earlier order reflects is this. The court is not inclined to issue page 56. Any declaration as sought for, it is their repetition. However, it is observed that the rejection such and such,
Because what declaration first you say?
a prayer for both the repetition
You
approach the
read
court
to-
seeking
you
law
go to-
declaration.
You go to
As regards other relief,
paragraph 5.
my lord, here, for demarcation as well as for correction of records, same being now as taken consideration by the circle officer, court directs circle officer to bring proceeding to a logical conclusion. Not only 202 and 205, logical conclusion of, my lord, where it is said that that has to be taken care of by 202 and 205. Nothing has been said that way. Logical conclusion. Because, my lord, they are claiming that they have a right of 205. But it is page 35 what will reflect, my lord. Your lordship will
Come to
find
paragraph 5.
paragraph 5.
This circle
And 6.
duly. Deciding.
Ultimately, direction was different. Maybe their prayer, maybe in the repetition, but the direction is that
Second
to come to a logical conclusion.
Promissory release of the given Now paragraph 10.
10. Now coming to the, it is in the, among the reliefs or one of the relief is the court declare petitioner owner of tag number such and such, and that respondent are the owners of such and such and such and such. In my opinion, the court such relief cannot be granted in a proceeding if it deserves declaration to civil court. As two other relief, the respondent authorities taking up action consequence of notice issued such and such. The court is observed the matter is pending before the circle office. The petitioner will be well advised to appropriate steps before the said. That is only there, man. As a specific direction for 205 and 202, there is nothing as such. Logical conclusion. And my lord,
You have to see.
my lord, and my
Mr.
lord, the notice your lordship will find.
No,
My lord, notice your lordship will find.
no.
A demarcation for the land covered by 202 and tag number 205. And they were present in the plot. They were both present during the field verification and demarcation. And my lord, their whole case is on the basis of page 35. Allotment which was done after it was settled with us by paying premium to the government under the act.
No, we are not into your land, sir. Don't think for a moment that we are into questioning your ownership, your possession,
My lord,
your boundary,
my lord, my lord,
right?
my lord, my lord,
We are looking into his grievance.
my lord,
Your grievance has been mitigated
my lord,
by the report.
my lord, my lord.
You have the ownership of 202. You are in possession of 202.
My lord.
And your 202 land has been properly demarcated. We are not into that. We are not questioning that.
My lord,
It is a fact-finding inquiry.
my lord,
It has been recorded,
my lord,
right?
my lord,
We are looking into his grievance.
my lord,
Your grievances have been mitigated.
my lord,
You are firmly in possession of your own land.
my lord.
Your boundary have been demarcated. And it is his writ petition.
My lord, another one thing, my lord. If you
Let me have the, once again,
one thing, my lord, just one thing. My lord, now after the death of Rohitas Prasad, because of this writ petition, my lord, they are objecting to my mutation. I have filed a miscase also.
1 minute, we're looking into the writ petition. This proceeding, earlier proceeding was instituted because of some notice, right?
Notice.
1 minute. No, notice was page 55. Page 55, it was his application for demarcation.
His application, it's true. That notice was challenged by me and ultimately court
That was negated.
negated. And ultimately both were present before the plot and my lord, demarcation was done. With our records placed before the authority.
So application was by his father or Doyle Sondode. Notice was to that effect by the circle officer. Court observed that to take appropriate steps, circle officer is in seizing of the matter. Then direction to the circle officer to bring the said proceeding to a logical conclusion, right? So demarcation process culminates with what?
Case 60.
Is that
notice of-
regarding possession or boundaries? It was his application, it was his notice which was directed to be brought to a logical conclusion. In the process, their position, their claim of Rohitesh or all have been finalized. But so far as the petitioner is concerned, right or wrong, because court has said claim to be owner, that is a different issue. You go for civil suit for that.
Case 60 also, notice also clear, my.
Uh-huh.
Violation of 20205.
202, 205. Where is the reflection?
That reflection is not there.
Demarcation. But you have done so specifically for the other land, 205.
Use the record.
Then nothing there like that.
I have also gone through it. madam. Petitioner.
And whether any bar that somebody else is in possession, demarcation, I don't think there is bar.
This is also clear. This is location of 202,
Huh.
205.
Huh.
So my lord, if I could produce a record, my lord.
What should be for,
For me, my lord, demarcation has been taken place. Like the order passed by this order. Only my lord is not been reflected. It
Hmm.
can be only be clear through the records. The process undertaken for the demarcation of 202.
firstly, it must be reflected in the order itself. First condition. And if it is not, then it must be reflected in the contemporaneously maintained records. But I don't think it is available. Get the records day after tomorrow. Otherwise we'll direct. The demarcation process as made in respect of 202 must be done with respect to 205.
My lord, one thing, can I make a small prayer? My lord, that I is there for my mutation, how could they may not?
Wait till day after tomorrow.
Can it be a month?
One day this court is not sitting.
Tuesday, my lord, but let it remain part.
No, next week is not.
My lord, let it remain part, man. Part.
No, I'll not keep it. part.
Well,
Let it be part of my lord.
But let it be,
Monday, my lord.
let it remain part, man.
I'll produce a record, my lord. Record is needed, my.
You ask whether a record is available.
Yes, yes.
You just verbally take instruction. Because I don't think from the contents of the record, it is a wrong order, long order. I don't think he has done so. Let us see the notice.
This is page 65.
And he definitely the petitioner has the reason to be aggrieved. It was his application at whose instance the application for demarcation was moved, processed, the direction was made, and finally, in the order, there is no reflection that 205 line has been demarcated.
My lord,
It has been.
So it is arbitrary,
my lord, another one thing, your lordship will call for the records of the earlier two writ
not
petitions.
required.
My lord, their prayer is different.
No, we are into this only. Why
Because-
should we?
Because my lord,
When that has been culminated into a judgment,
my lord,
which has attained finality,
my lord,
why should we look into it?
my lord.
We are not into review of the
No, no.
earlier order.
Only thing is this, my lord,
We are carrying out from that point.
my lord, because of this, my lord, our whole plot of land where ownership.
That is why I am expressing urgency
My lord, I'm,
day after tomorrow.
my lord.
Otherwise, lest I forget.
No, my lord, no, at least your lordship may keep it part heard, man.
No, no. I will keep it.
Friday, man. Friday.
No, no, Friday will not be difficult. Thursday.
Thursday.
I look at the records, no? Pertaining to the order pass.
No. Not an old record.
Oh, yes, yes. I'll communicate it today itself.
Heard Mr. M.J. Bolwa, learned support of petitioners. Mr. N. Das, learned junior government advocate for the state respondents. Mr. P.K. Roy Chaudhary, learned counsel for the private respondents. Full stop. From the submissions of the learned counsel for the party. Sorry, no, a direction was made. In the order dated 17/12/2024. Passed in WBC number 5449/2019 and WBC number 7184/2021. To bring the demarcation proceeding in respect of the parcels of land under DAG number 202 old and DAG number 205 old to a logical conclusion. Full stop. In the order passed subsequently on 1/6/2024. In compliance of the direction, comma, only the parcel of land only the parcel of land covered by old DAG number 202 old is found to have been demarcated. And there is no reflection that the parcel of land covered by DAG number 205 has been similarly demarcated. Full stop. In such view of the matter, comma, Mr. Das, learned counsel for during for the state response submitted that he will make an endeavor to obtain the relevant records. List that is on Thursday. Otherwise, these dark numbers and so and so.
Will go.
Once it goes out of my mind, it goes. Again, I have to concentrate.
2011.
Objection.
2011.
Time being better. Item 12.
Undu? Huh? It. Yes.
I'm waiting for the senior. For the timing.
Instruction. Like you say.
So sorry, your lordship, matter was going on there. Listen again. The new executive council was formed on 25/9/2025, my lord. And decision was taken by the executive council, clause 4.9 of the notification, my lord. Minutes of the first executive council meeting on 14/10/2025, clause 4.9. The EC decided to dissolve the centers so and so constituted.
Yes, Mr. Rava. Though the
1410.
this can be set aside.
I don't
This
think
can be set aside.
it was preceded by any executive council.
No, this will be set aside. These two can be set aside. But that revives.
Yes.
Have you understood? Without executive council decision, this is done. So these are set aside. But that springs into action. 4.9, you can see. That is the executive council decision. Just show him 4.9.
Yes. The doctor.
This will go. Huh?
Has not been made known to us. How do we challenge?
This will go, but that springs into action.
But till date, we are holding charge and we are not aware
How
of
could
this
it
for
be?
1410.
How could it be? The new council has taken.
14 October.
Yes, 14 October.
Then whether it has been notified.
14 October, the notification.
Like the notification office memorandum
Yes. Yes.
that dissolved.
Yes.
Pursuant to executive council decision.
Yes, your lordship.
So something in the file
Yeah.
not communicated is no order at all. See,
I understand.
you have understood. So if that is notified, because this is that is not the only decision. There are many decisions.
Yes.
In the executive council meeting. Apart from 4.9, there are many decisions,
Yes.
executive decisions.
Lordship.
So whether that has been notified.
The notification. They were very much as they are saying, they have not handed over. They were holding the office. Is it like?
No, this still does not survive. This OM
We will
dated
not know.
9/10/2025 does not survive because there was no executive council decision.
Has to be preceded.
It was as per the desire of the.
Yes,
Civic.
if these two would go, go lordship, the other one will still remain.
Because
Yes.
meeting first executive council meeting
Yes, my lord.
was held on 14 October.
Yes.
So there was no executive council decision.
Resolution was prior to the holding of the council meeting. It has
Desire
to be-
was on
it has to-
9th. Desire was on 9th.
Yes.
First executive council meeting was
Yes.
on 14th.
Yes.
Meaning thereby the removal was not as per the earlier three notifications. Right.
And maybe.
So this 9th October can be set aside.
Yes, but what about the?
We don't know about that.
Yes. That too can be set aside, but still lordship, the other one will still remain. They have not challenged it.
No.
They said they don't, they,
An
that, would-
order.
that plea, your lordship, they would always take, but they were very much in
So-
the office as they are saying, my
Okay, that
lord.
will, they will decide, but this can be set aside. At least kept in abeyance.
Ex specie arbitrary.
This can be kept in abeyance. Whether that springs into action,
My lord,
something which is passed
my lord,
inside the office
my lord.
and not communicated to the affected
That
person.
I have to, lordship, so for end of justice, my learned senior firm will not be available, Mr. Chaudhary. Can it be taken up tomorrow? I'll take space, because by WhatsApp, they
Yes.
come.
It is notified. Otherwise,
You will not be.
this will be kept in
Senior
abeyance.
people.
This can be kept in abeyance.
Tomorrow, my lord.
But that, if that has springed into action, then again, we have to look into both the factors.
Lordship.
But if it springs to action overnight, that is my only anxiety.
My submission is that they say they are very much in the office, they were functioning. Will not they know, my lord? They, lordship, they suppress the various material facts before this honorable
No,
court.
I have stated it, both.
Okay.
It is unknown. They were functioning in the Procurator, the secretary, that they will not know about the developments.
Because you are nominated. Not that elected or statutory body.
Body.
It is not a statutory body. It looks like, no. That was as per the desire of the earlier executive council.
Some protection, even the desire, it springs up overnight.
The decision is there.
Don't get a chance to tell him.
Let us take it up tomorrow, your lordship. I'll bring instruction, my lord. Maybe at 2, my lord, 2 o'clock.
Two.
Only tell
Okay. You have a copy of this?
Times after.
I'll give a copy to them.
Hand it over. Because it is a collective decision ultimately. It is a collective decision
Tomorrow, my lord.
and by elected body. Elected body taking a decision against nomination. So there are some
We are not questioning that, my lord.
otherwise pleasure.
Pleasure. Even notice is not
Regarding
required.
removal.
We are not into that, my lord.
Okay, yes.
The manner in
N.K.
which
Chaudhary, Senior Counsel, State by Mr. S.R. Rava, for Ms. P. Yeah, yes, you are standing up.
Appear for BTC, yes, thank you.
Okay, Counsel, Senior Counsel, listed by Mr.
M.
M. K. Das for the respondent BTC authorities. So, Ms. Priya has sought listing of the case. More of to place further instruction matter. Please the case to.
At 2 p.m.
Okay.
Fine.
Pick up after motion matters.
Lordship, obliged.
Third method, item 11.
The asking you. A. I've got a judgment. These are the two. I marked the paragraphs, I think 44. About 100 repetitions from Bombay, Madras, Delhi. Mahakali, you read Mahakali first.
Mahakali. What?
Have you read?
Yes, my
You
lord.
have the copy?
Yes, my lord. Yes, my lord.
Ah.
Mahakali. And Mahakali is there, my lord. But it is inapplicable in our, I think it is inapplicable.
Okay, your
my consideration,
submission.
Because my lord, termination for work is
Termination you cannot enforce. This is a non-statutory contract. এই কোৰিয়ানটো আছে নেকি তাতে?
Because we have objected before the council, my lord.
বুলি
that,
কালি আছিল।
with documentary evidence that he has failed to oblige the terms and conditions of the chamber.
Hand it over the other one. Now take up then Mohakali. You have the Mohakali?
Yes, my lord.
Copy of Mohakali?
Yes, my lord. Para 5, my
Second judgment to due.
Para 5. Mohakali.
There are about hundreds of writ petitions from different high courts. Para 11. In the background, in a background of aforestated spectrum of cases, the following common questions of law arise for consideration. Whether the provisions of Chapter 5 of the MS MED Act 2006 would have an effect overriding the provisions of the Arbitration Act. Next, whether any party to a dispute with regard to any amount due under Section 17 of the MS MED Act would be precluded from making a reference to the Micro and Small Enterprises Felicitation Council under subsection 1 of Section 18. If an independent arbitration agreement, which you say
Yes.
existed between the parties as contemplated in Section 7 of the Arbitration Act. You also say that GM contract contains an arbitration clause. Right? Then 11.3. Whether the Micro and Small Enterprises Facilitation Council itself could take up, that is not the issue here. That has been done. They took up conciliation, failed, they forwarded it to Delhi Arbitration Center. So that question is also answered. Now come to all these provisions 16, 17, 18 are referred to Arbitration Act have been referred to. Then 29.12. No, not. 36. Keeping in view.
My lord, to which para?
36. Have you got it? You have a SCC or some other issue?
My lord, live laws.
Okay, the word, the paragraph starts with keeping in view.
Para 20. Yes, my lord. In view.
Read.
If in view the aforesaid principles of history interpretations as also the proposition of law laid down by this court with regard to the general rules of construction, let us proceed to examine whether the MSMED Act 2000 is a special in it having an effect override the Arbitration Act 1990, which is received to be a general enactment. As stated earlier, the very object of enactment of Employment Act 6 was to facilitate the promotion of development and enhance the competitiveness of micro, small and medium enterprises. This act also aimed to ensure timely and a smooth flow of credit to the micro, small, medium enterprises to minimize the sense of this. One of the main objects of the act was to delete the interest on delayed payment to small scale and ancillary industries undertaking act. Three, to include provisions as also to provide this solution mechanic for solving the put of non-payment of dues to the micro and small enterprises. Thus, the seed of MSME Act 2006 has out for the need of the comprehensive legislation, provide an appropriate legal framework and extend support to the micro enterprises.
Then
Enable them.
38.
My lord,
38. Section 18. First word.
Section 18, 22. 18, which is non-obstant clause, notwithstanding anything contained in any other law for the time being in force. It means that the said provision has been enacted with the aim to supersede the laws for the time being in force. Further, as decided, dedicated statutory program, that is the Micro and Small Enterprise Facilitation Council, as established under Section 20 of the MSME Act 2006, has been provided for which a reference could be made by any party to the subsection of the Section 18 empowers the Facilitation Council on receipt of such reference made under such section. One, to conduct conciliation in the matter or seek assistance of any institution, center provided alternate distribution service by making a reference to such an institution or center for conducting the conciliation as contemplated in section 65 to 81 of the Arbitration Act 1996. If the constitution initiated under subject 2 is not successful and stand terminated without any settlement between the parties, the council further empowers the secretary to either itself to take up the dispute for arbitration or refer to any institution or center providing alternate dispute resolution services for such arbitration. The provision of Arbitration Act 1990 are then made applicable to the dispute as if the arbitration was in pursuance of arbitration agreement referred subsection 1 of 7 of the arbitration. 6. Subsection 4 of section 15 again stated starts with a non-obstant clause, that is notwithstanding anything contained any other law for the time being used, and confers jurisdiction over the facilitation council to act as an arbitrator or conciliator in a dispute between the
Then
supplier
come to
within the-
40.5. Basically
price-
18.4, 18.4, 40.5. The facilitation council or the centers providing alternative dispute.
The facility.
Anyway, you read
Council
from
or the
paragraph
centers
42.
Providing alternative dispute resolution service have been conferred with the jurisdiction act as an arbitrator and conciliator under section 18(4), not saying anything containing any other law for the time being used in a dispute
Between the supplier located within its jurisdiction. That is section 18(4). Right?
Yes.
Now come to paragraph 42. Paragraph 42 starts with, does the Arbitration Act
Thus, the Arbitration Act 1990 general governs the law of arbitration. Consultation, whereas the MSC Act, MSMED Act 2006 governs specific share of the arising out between specific categories of persons to be resolved by following a specific post or a specific forum. Ergo, the MSMED Act 2006 being a special law and Arbitration Act 1996 being a general law, the provision of MSMED Act would have precedence over and prevail over the Arbitration Act 1996. In Silfi Industries case, also this court has observed while considering the issue with regard to the maintainability and counterclaim in arbitration proceeding initiated as per section 18(3) of the MSMED Act 2006, that the MSMED Act 2006 is being a special legislation to protect MSMEs by setting out a mechanism for the payment of interest and delay payment, and the state act would override the provision of the Arbitration Act 1996, which is a general legislation. Even if the Arbitration Act is treated as a special law, then also the MSMED Act having been enacted subsequently in point of time, that is in 2006, it would have a overriding effect, more particularly in view of section 25 of MSMED Act, which is special given an effect to the provisions of section 15 to 23 of the Act over any other laws for the time being in force, which would also include.
Okay, now 44. The submissions made. Now, this is pertinent to your case. The submissions made on behalf of the council for the buyers. You are a buyer.
Yes, my lord, I am buyer.
The word starts with the submission.
The submission made on behalf of the council for the buyer that a conscientious
Conscious omission of the word agreement.
Agreement in subsection 1 of section 18, which otherwise find mentioned in the section 16 of the MS. It implies that the
Arbitration agreement, that is clause 16 of your GM contract.
Yes, my lord.
Independently entered into between the parties.
As
Contemplated under section 7 of the Arbitration Act.
Was
not intended to be superseded.
By the provision
Also contained of section 18 of the MSME Act also cannot be accepted. Right? Read further.
A private agreement between the parties cannot obliterate the
Your GM contract is private contract.
But if
No.
my lord, the hospital is
No. If you don't know, then I can't explain you.
But,
This is a private agreement and non-statutory agreement. I'll come to it later on. Read. You have a question, doubt that your agreement is statutory contract,
under
non-statutory contract. And it is only a private contract, which is to be governed by private law under the provisions of Contract Act. A private agreement, read.
once the statutory mechanism under a private agreement between the parties cannot obliterate the statutory provisions. Once the statutory mechanism under subsection 1 of the section 10 is triggered,
It would override.
it would override any other agreement independent entered in between the parties in view of the non-constant clause contained in subsection 1 and subsection 4 of section 18. the provisions of section 15 to 23 have also override effect as contemplated in section 24 of the MSMED. When anything inconsistent is contained in any other law or the timing rules, it cannot be changed that while interpreting a statute, if two interpretations are possible, the one which enhance the object of the act should be preferred than the one which would frustrate the object of the act. If submission made by the learned counsel for the buyer that the party to a dispute covered under the MSME Act cannot avail the remedy available under section 18 of MSME Act 2000, when an independent arbitration agreement.
You are saying independent
Yes.
arbitration agreement.
Yes, my lord.
Read further. Between the parties exist is accepted. The very purpose of enacting MSMED Act would get frustrated. Now come to para 46. Your submission. The submission therefore,
My lord, which is the.
page for para 46. Starts with the submission therefore. You just read para 44, right?
Yes.
Next to next para. Next para is there
The
cannot
court
be any
cannot,
disagreement.
lose sight of the specific announcement
Huh?
contained. The submissions made.
No, therefore.
Therefore, but
Ah.
there cannot be any. Is the my lord.
Next para. Next para. You skip that one.
That the aforesaid legal position.
No, before that.
The
You read-
submission therefore.
Huh.
That an independent arbitration agreement entered into between the parties under the Arbitration Act 1996 would prevail over the statutory provision of MSMED Act 2006.
Cannot be
con-
countenanced.
As such, subsection 1 of section 18 of MSMED Act 2006 is an enabling provision which gives the party to a cover under the section 70 thereof. A choice to approach the facilitation council despite an arbitration agreement existing between the parties. Absence of the word agreement.
Yes. See.
In the said provision would neither be a construed a omniscience
In the
in
statute.
the statute, nor be a construed as a recluse against the party to a dispute covered under section 7 to approach the Facilitation Council on the ground that there is an arbitration between the
Yes.
parties.
Now, your case.
My lord,
You appointed an arbitrator. And you asked him to appoint an arbitrator. He did not do so. He went to the Facilitation Council. That is the answer. He will not do. He go to the Facilitation Council. That is made clear.
But
No but and if.
one thing that, my lord, yes, we have terminated as per the German. Terminated.
That answer is also there. First, the answer is you appointed an arbitrator and asked him to appoint an arbitrator. He did not do so. He went to Facilitation Council, right? Then Facilitation Council issued a notice, right? That answer is there. He will not go by the arbitration agreement. He will go by MSMED Act. that has because of the the overriding power, that will give effect. That is the answer. Now you proceed further. He may not go and appoint arbitrator. He can opt for facilitation council.
Before facilitation council, I submitted that we have communicated.
Answer is there, Mr. Lotto.
Yes.
Go further. Go further. Good further reading.
Council, that's it. And therefore, mere because of there is an arbitration agreement existing between the parties. And the aforesaid legal position also dispels the argument advanced on behalf of the council for the buyer that the facilitation council having acted as a conciliator under section 18(2) of the MSME Act itself cannot take up the dispute for arbitration and arbitration aspect of and act or as an arbitrator, though it is true that the section 80 of the arbitration contained a bar that the conciliator shall not act as an arbitrator in any arbitration proceeding in respect of a dispute that is subject of conciliation proceedings. The said bar stands persisted by the provision contained in related to of the MSP Act. As held earlier, the provision contained in Chapter 5 of the MSP Act having an effect override the provisions of the Arbitration 96. The provisions of Arbitration Act 1996 would apply to the process conducted by the facility council only after the process of conciliation initiated by the council under section fails. The council either it shall take up the dispute for arbitration or refer to any institution center for such arbitration as contemplated the section. This is my question. Refer to Delhi Internet.
Your agreement, arbitration agreement also there shall have all the powers to decide. Next.
When the facilitation council or the institution of the center act as an arbitrator, it shall have all power to decide the dispute referred to it as if such arbitration was in pursuance of the arbitration agreement referred to the subsection 1 of the section of the Arbitration Act 1996. Then all the traffic of arbitration would apply to such arbitration. It is needless to say that such facilitation council institution center acting as an arbitral tribunal would also be competent to rule on its own jurisdiction like any other arbitral tribunal appointed under the Arbitration Act 1996 would have contemplated in the section.
So thereafter the second judgment. Seat of arbitration is decided where a supplier resides. Now, all disputes are similar kind of that it is not a case of non-payment. It is breaches of the GM contract. So we are not liable to pay. All these are open to be raised before the arbitration.
But in Delhi,
Delhi. Everybody surrendered. Learned Solicitor General, in this case, after Mohakali, submits that the decision of the court should not in any way prejudice any rights or contentions that his client may legitimately raise and contest before the arbitral tribunal. He surrendered, Solicitor General for Union of India in the second judgment. Then he says, then court says, we have no hesitation in clarifying that we have not touched upon the merits of the matter. We also direct the learned arbitrator to permit the parties to raise and argue all questions of law and facts as are legally permissible. You have to raise all this, that this is a breaches of the terms and conditions, and we are not liable to pay him anything. Right? All these can be raised, but question is that this arbitration agreement stands superseded once the supplier approaches the Felicitation Council. That is a problem. Now your prayer.
Yes, my lord.
Now your prayer.
But,
Your prayers, see the prayers.
so what the sanctity of the dam? That is on the other hand, government.
All
to,
the sanctity, if you want to know sanctity,
terms and
I'll
conditions
just
with regard
say one line. The interpretation and implementation of a clause in a contract cannot be the subject matter of a writ petition. If a term of a contract is violated, the remedy is not the writ petition under Article 226. A contract would not become statutory simply because it is for construction of a public utility, like you, or an instrumentality of the state under 12. And it has been awarded by a statutory body. You are not even statutory body. Since obligations imposed by the contract on the contracting parties come within the purview of the Contract Act, that would not make the contract statutory. Disputes arising out of the terms of such contract or alleged breaches have to be settled by ordinary principles of law of contract. The fact that one of the parties to the agreement is a statutory body or a public body will not by itself affect the principles to be applied. The dispute about the meaning of a covenant in a contract or its enforceability have to be determined according to the usual principles of Contract Act. Such activities may not raise any public issue or issue in public law. The contract between the parties is in the realm of private law. It is not a statutory contract. The disputes relating to interpretation of the terms and contracts, conditions of such a contract could not be agitated in a petition under Article 226 of the Constitution of India. That is a matter to be adjudicated by a civil court or if in arbitration, if provided for in the contract. Law is simple. Now come to your prayer. First, prayer number 2. The impugn arbitration proceeding by case number so and so at Delhi International Arbitration Center for having no jurisdiction, which violates clause 16.2 of GEM, Terms and Contract, ignoring petitioner's initiation of arbitration on so and so, as per clause so and condition so and so, objection so and so, to the MSME Felicitation Council. This goes. This goes. Come to prayer 1. Impugn process taken by the respondents, declaring that the petition of respondent number 1, that is supplier, against the termination order issued by the petitioner under so and so MSE is not maintainable as per clause so and so. You have to raise the dispute there. You have to raise all disputes open to you under law, that this is breaches of contract. So his claim of money of 48 lakh or something in the application is not tenable. Then come to 3. Appropriate writ restraining the respondent 2 and 3 from proceeding further with the arbitration until the jurisdiction issue is finally decided. Decided. No writ. Then 4. A direction to the respondent number 1 to resolve the dispute as mandated under who is respondent number 1
That's one of the party.
That goes,
Taylor.
nothing remains.
With
We are
the-
deciding on the preliminary point, not on the merits.
Observing that the
All points,
raise this question for the arbitration.
yes. Open for all permissible grounds
Because,
under the law.
Because
But it is an interesting case.
my lord, but how can I prepare this? I don't
No,
know.
he prepared well, but I have also seen, I had some idea that this might not be,
It gave me some trouble, my lord. But only is that the because of that the 18 of Assam Act, the applicable for due payment. But we have paid all the dues to the
he has raised down. That prevails over your ground. For the purpose of jurisdiction, it goes to the facilitation council, then thereafter arbitration. There you raise all the point. You already raised the jurisdiction ground under section 16. That has been discarded, right? Now answer is there. Section 16 of the Arbitration Conciliation Act. A party aggrieved by such an arbitral award make an application for setting aside such arbitral award in accordance with section 34. Under section 34, you can again raise the ground of jurisdiction. This law has been framed like this. So today or tomorrow I'll pass the order. We are showing
because as per our request by the proceeding is the proceeding before the arbitration is delayed. Because of that, I will inform them that we have filed petition before this court. Madam,
kept in abeyance. So they were keeping in abeyance. So we are deciding and dismissing your repetition on the preliminary point. So the proceeding may resume. There you take all the grounds.
without objection. Jurisdiction already.
No, jurisdiction you can raise again. We are deciding maintainability of the writ petition only. Nothing on merits. You raise all the grounds there before the arbitrator that his claim for so and so amount is not maintainable. You raise all the ground. No way out. Otherwise, I would have entertained. Our hands are tied. This was chamber lomba ho na.